a galactically wasteful policy. But he's quite right on the fact that so much of this is about choices and priorities, and the choices and priorities that the government has shown are simply the wrong ones in terms of wasting very valuable taxpayers' money that could be so better focused elsewhere. And that is why we support Lord's Amendment 8, Mr. Speaker, which is a Labour frontbench amendment in the name of the noble Lord Coker. This amendment requires the government to report on the timetable for removing inadmissible asylum seekers under the Illegal Migration Act. We absolutely need to see accountability over the inadmissibility provisions that have created that perma-backlog of 55,000 small boat asylum seekers stuck in limbo, unable to be processed. So perhaps the Minister could tell us now, if 99% of the people crossing in small boats are not likely to be sent to Rwanda, then what will happen to them? Will the Minister just now admit that in spite of all his bluff and bluster, they will simply be let into our asylum system after all? I don't know if he wants to. No. The whole premise of inadmissibility was always a one-way street to limbo and shambles, as the Shadow Home Secretary and I have warned the ministers in this chamber continuously over the past 2 years. There is, of course, an alternative. I hope members opposite have been listening, because for the last 18 months at this dispatch box, myself and my right honourable friend, the Shadow Home Secretary, have been absolutely clear on how Labour will prevent the dangerous and life-threatening channel crossings, and how we will also fix our broken asylum system. I've already mentioned how we would redirect the money set aside for the Rwandan government into a cross-border police unit and intelligence-sharing security partnership with Europol in order to smash the criminal smuggler gangs upstream. But as part of our plan, we would also ensure people who have no right to be here are removed to a safe third country. Since 2010, under the Tories, removals have collapsed. The returns of foreign national offenders have fallen by 27%, and the returns of failed asylum seekers have fallen by 44%. Under Labour's plan, a new returns and enforcement unit would include 1,000 additional officials to expedite removals, with £35 million set aside to create new Nightingale courts to fast-track appeals and to pursue tougher action on employers who employ migrants illegally.
I thank the Shadow Minister for giving way. He says he wants removals to a safe third country. Which one?
I thank the honourable. Sorry, I'm very sorry. Would the honourable member just mind repeating that? I was just.
Oh, thank you. Well, it's always good to listen to an intervention, but I'll repeat it for him. He said he would. One of these parts of his plan would be to remove people to a safe third country. Simple question. If not Rwanda, which one? I
apologise. It should have said home country. I should have said home country. I misspoke, and I'd like to correct the record. I'm sorry. It was home country. Apologies. I misspoke there. Labour's common-sense, pragmatic plan will smash the business model of the criminal gangs, deter dangerous journeys and tackle the backlog. Mr. Speaker, I will in 1 second. With your permission, I will now run through the remaining 9 amendments that have come to us from the other place. We support each of them for the reasons that I will now set out.
I'm grateful for giving way. How much would Labour's plan cost?
As I've already said, I don't know if the honourable member was listening, this is about repurposing the vast quantities of taxpayers' money that are being squandered on his harebrained Rwanda plan, and that rechanneling of that money will fund the clearance of the backlog, the sorting out returns and smashing the criminal gangs. Now, I would first like to focus on Lord's Amendment 10, tabled by the noble Lord Brown. This amendment seeks to exempt individuals who have worked in support of the UK government or armed forces from removal to Rwanda under the provisions of this bill. This amendment is driven by a moral imperative, Mr. Deputy Speaker. We owe a debt of gratitude to those who have supported our defence, diplomacy and development abroad, not least in Afghanistan, and it beggars belief that the government would even consider sending this cohort of heroes who are fleeing the Taliban to Rwanda. Britain's commitment towards these loyal to Britain Afghans is, of course, felt most strongly by our own armed forces. But this government has continually shirked its responsibilities towards Afghans, including by leaving thousands of those with a right to be in the UK stranded in Pakistan for more than a year. Little wonder that they have resorted to making these desperate journeys across the Channel. Operation Warm Welcome has become Operation Cold Shoulder, Mr. Deputy Speaker.
talking about he wants more Afghanistani people to come from Pakistan to UK. How many more immigrants does he want to come to the UK from Afghanistan?
Well, the amendment is about stopping them being sent to Rwanda, but let's be absolutely clear. There are many, many Afghans who have been identified by the government under the ARAP and ACRS schemes. Those are the people that are languishing in Pakistan because this government we of course remember the Prime Minister's memo to Whitehall saying, by the way, everybody, let's slow pedal on these Afghans who are in Pakistan who have been identified for resettlement under the ACRS and ARAP. So if he wants to know the number, I recommend that he goes to his own government and asks how many have been identified under ARAP and ACRS. I will give way.
I'm grateful to him for giving way. In my own constituency, I met one family who were in a similar situation where the constituent's husband had been killed in Afghanistan and still in this limbo land because of the delay in decision making. And also, is he aware that there is now a situation where Pakistan is forcing Afghan asylum seekers back to Afghanistan, and there are tens of thousands of people in that situation, some of whom will be those who worked to support our forces during the war in Afghanistan.
Well, and that, of course, my honourable friend is absolutely right, because that is the scope of this amendment tabled in the name of Lord Brown, is specifically for those who served shoulder to shoulder with our armed forces and our diplomatic and our development efforts in Afghanistan. So these are people to whom the United Kingdom owes a debt of honour and a debt of gratitude. I'm not sure honour is a word that we can apply very easily to the benches opposite, but that is what it's about. Lord's Amendment number 9 in the name... I will just... in one, if I will... yes, thank you. Lord's Amendment number 9 in the name of the noble Baroness Butler-Sloss is also based on a moral imperative, Mr Deputy Speaker, as it would prevent the removal of potential victims of modern slavery to Rwanda until they receive a decision from the government on whether there is credible evidence that the person is a modern slavery victim. It really should go without saying that modern slavery victims should not be being sent to Rwanda. But sadly, with this government, basic moral decency is a scarce commodity.
On both 9 and 10, can I just say, those of us who've dealt with both traffic victims and also those of us who've dealt with those who served us in Afghanistan, this indicates some loss of moral compass here somewhere. And with regard to those who served us in Afghanistan in a whole range of different functions, they have survived just to get out of the country, having been chased by the Afghani Taliban. Their families have been harassed. Some of them have got to Pakistan and then been threatened with force back over the border again. They've got to us traumatised, and we're going to traumatise them again by sending them to Rwanda. This cannot be right, and I can't believe honourable members who've dealt with any of these cases could not support these amendments, because it's human suffering in the extreme, but particularly with those who've served us, human suffering brought about by their loyalty to us.
Well, I thank my honourable friend for that intervention, and he makes the case with passion and conviction. I know that he also has a number of asylum seekers and refugees in his constituency, and he does a huge amount of work on their behalf. I think he's absolutely right that there are some issues which should really transcend the day-to-day political considerations that we have in this place, because they are issues that are based on moral imperatives. And it is deeply disappointing that in both of these amendments that he mentions, the government has refused to even have the basis for a negotiation or some kind of compromise to allow. And we do find that deeply disappointing. I will give them.
Would you agree with me in answer to the earlier question that was posed to him, how many? That the simple answer is all those who served, who risked their lives to help us in a war which required the support of the local population those people, if they're in danger, and if we've got records of the help that they gave and the support which they gave, surely we can't turn our back on those individuals.
I thank the honourable gentleman, and what a contrast between his intervention and the intervention of the gentleman on the other benches. I genuinely believe that when the gentleman on the opposite benches reflects, he will regret the intervention that he made, and perhaps he could reflect on what the honourable gentleman on the bench behind said. We on these benches are also profoundly concerned about unaccompanied children being inadvertently sent to Rwanda. For this reason, we support Lord's Amendment 7 in the name of the noble Baroness Lister, which reverses changes to age assessment procedures established by the Illegal Migration Act in relation specifically to removals to Rwanda. It restores the ability of domestic courts and tribunals to fully consider suspensive judicial review claims regarding removal decisions taken on the basis of age assessment of unaccompanied children. Lord's Amendments 1 to 6 all relate to the rule of law. We support all of these amendments, and they are all principles that government ministers have said that they agree with. Indeed, the simple question that should be asked in relation to each one of these amendments is this: if ministers believe that Rwanda is a safe country, then why is the government refusing to support these amendments? They say that this bill abides by international law, so why not just make that clear on the face of the bill? They say that Rwanda is a safe country and is meeting its obligations, so let's see the evidence and agree but a trust but verify mechanism. In this spirit, Lord's Amendment 1 is a Labour frontbench amendment which places a responsibility on the government to comply in full with its current obligations under domestic and international law. Lord's Amendment 2 and...
I'm grateful to the honourable gentleman for giving way, but does he not accept that Amendment 1 is entirely OTO's? In terms of compliance with domestic law, this bill, when enacted, will be an element of domestic law. And in terms of compliance with international law, isn't it the case that it's predicated on international law, that is to say, the Rwanda Treaty?
Well, if that's the case, then why aren't government ministers accepting the amendment? I mean, it is simply those with a great deal more constitutional expertise than I in the other place, seeking reassurances that our democratic conventions, that our obligations in terms of alignment with the rule of law, will be respected. And as the honourable gentleman has pointed out, if that's the case, then surely these amendments should be perfectly acceptable to the government.
I thank the man for giving way. Perhaps I can help shed light on this, because the government minister has just shown that the government is not abiding by its international obligations. The Good Friday Agreement explicitly commits us to working together, those words are in it, with the Irish government when it comes to the rights of individuals in Northern Ireland. This piece of legislation will deny rights to individuals in Northern Ireland, and yet the government minister has admitted they have not even consulted the Irish government. So does my honourable member agree with me? Our word is our bond as a country, and if we show we can't be trusted to stand up for international law, it's absolutely right that this place demands the government puts it on the face of a bill.
Well, I agree with my honourable friend. She makes a very clear case. I would also say, of course, there's a lot of rhetoric that has accompanied this bill around the ECHR and the United Kingdom's obligations in international law, and the implications of that for the Good Friday Agreement are truly chilling. The way in which the benches opposite are prepared to sabre rattle and use rhetoric in a way that undermines our reliability as a partner that can be trusted to respect our international legal obligations is frankly shameful and deeply concerning, and not least in the case of the Good Friday Agreement. Lord's Amendments 2 and 3, in the name of the noble Lord Hope, state that Rwanda may only be considered to be a safe country if and when the measures set out in the Rwanda Treaty have been fully implemented, and the Monitoring Committee has established that this is the case. The government claims that the measures in the treaty address concerns in the Supreme Court's recent ruling, so there is absolutely no reason why ministers should refuse to accept Lord Hope's amendments. Lord's Amendments 4 and 5, in the name of the noble Lord Anderson, state that Rwanda can be considered a safe country unless there is credible evidence to the contrary, as determined by a court or tribunal. Following the Supreme Court's ruling, the government itself accepted that the situation in Rwanda is not static, but evolving. as it is in every other country on the face of the earth, Mr. Deputy Speaker. So if the government accepts that Rwanda could one day become safer for asylum seekers that are sent there from the UK, it must by definition also accept that it could one day deteriorate. Lord Anderson's amendments simply provide a basis for assessing the situation on the ground in Rwanda and acting accordingly. Finally,
friend for giving way. A joint statement signed by over 260 civil society organisations has branded this bill, quote, a constitutionally extraordinary and deeply harmful piece of legislation that threatens the universality of human rights and is likely in breach of international law, striking a serious blow to the UK's commitment to the rule of law. Would my friend agree that this bill represents an unethical gimmick that will potentially put vulnerable people, very vulnerable people, at risk and harm the UK's reputation on the world stage?
Well, I thank my honourable friend for that intervention, and she's absolutely right. And just think if, as I was saying, if the amount of time and energy that's been wasted on this madcap bill, which is also a constitutional outrage, unaffordable, unlawful and unworkable, had been actually put into addressing some of the challenges that we face in a pragmatic way, just think where we could have got to by today. So finally, the Lord's Amendment 6, in the name of the noble Baroness Chakrabarti, allows government ministers, officials and courts to consider whether Rwanda is safe on a case-by-case basis. Given that the government has accepted that some appeals will be allowed, we see no reason for the government to reject this amendment. Mr. Deputy Speaker, after 14 years of incompetent and negligent governance, our asylum system is in a mess. The Conservatives have presided over a backlog of 130,000 asylum seekers, despite ministers attempting to pull the wool over the public's eyes through administrative withdrawals and various other ruses. There are still 46,000 asylum seekers in taxpayer-funded hotels, contributing to an asylum system which now costs 10 times what it did under Labour at an eye-watering £5.4 billion. And only last week we discovered there were major problems with a broken immigration IT system, which has mixed up details of applicants affecting a staggering 76,000 people. But this con of a bill is not the way to fix the problems that this Conservative government has created. The highest court in our land has ruled unanimously that Rwanda is not a safe country, and no amount of ludicrous legislation like this bill can change that fact. The government may well wish to say that the sky is green and the grass is blue, but introducing an Act of Parliament will never make it so. And even the benches opposite recognise this bill is on a hiding to nothing, Mr. Deputy Speaker. Indeed, a former Home Secretary has stated that it is highly unlikely to work, and the former Immigration Minister has described the government's aim as being to get a few, and I quote, symbolic half-filled flights taking off this spring, rather than having a plan that is a genuine attempt to tackle the dangerous channel crossings. So it is probably also no surprise that ministers are finally now turning to Plan B, paying people a reported £3,000 per head to go to Rwanda instead. Can this really be true? And if so, would the Minister like to take the opportunity to enlighten the House today on some of the details? Would this £3,000 per head come on top of the £570 million cost we already know about? Will there be another treaty between the UK and Rwanda to implement this? And if so, will he publish it? Have the NAO done an assessment of these additional costs, and will the House be able to vote on this new plan that has been briefed? I await the Minister's responses with interest. Mr. Deputy Speaker, this bill is a con. The treaty is a con. The whole Rwanda plan is a con. It is quite simply a headline-chasing gimmick, as unworkable as it is unaffordable. The country knows it. This House knows it. The Home Secretary knows it. And the Minister knows it. At £2 million per head, the Rwanda scheme is the worst value for money policy in history. But the amendments that I have spoken to today will not stop flights taking off. We expect those flights to happen this spring, as the Prime Minister has repeatedly promised the country. These amendments simply seek to insert into the bill what ministers have promised. So I encourage members on all sides of the House to join me in the division lobbies supporting these amendments later today. Thank you very much.
Order, order, order. Just before we proceed, the government and opposition front benches have perhaps understandably taken a certain amount of leeway in a broad brush approach to this debate. Can I remind the back benches that we are now debating Lord's amendments. This is not a second reading debate. So Jeremy Wright.
Thank you very much indeed, Mr. Deputy Speaker. And can I begin with an apology to you and to others in the chamber for the fact that I will not be in the chamber for some part of this debate due to some other parliamentary business I have to attend. But I want to start my remarks by recalling that the fundamental purpose of this bill is to locate the decision on whether Rwanda is a safe country to send people to with Parliament, rather than with decision makers in individual cases or with courts reviewing those cases. And I say that, Mr. Deputy Speaker, because a number of the amendments before us today seek to undermine that fundamental purpose by transferring decisions on that question away from Parliament again and back to the caseworkers and courts. And so they are, I'm afraid, wrecking amendments. They are incredibly elegant wrecking amendments, and they come from an honourable and fundamental opposition to the purpose of the bill, and an opposition which, Mr. Deputy Speaker, I entirely understand. I will confess to the House that I did not find voting for this legislation a comfortable choice. It comes very close to the line on rule of law acceptability, but in my view stays just the right side of it. And crucially, it asserts parliamentary sovereignty on an issue of huge political significance, where that issue is central to the delivery of a key government policy. And that significant and central issue is whether the government of the day is entitled to pursue a policy on illegal immigration that contains an element of effective deterrence. And I think the government must be able to do that. And for a deterrent to be effective, it must be clear. The deterrent to those who are really economic migrants seeking to reach the UK under cover of our asylum system is that they may end up in a different country instead, in this case, Rwanda. In order for that deterrent to be meaningful, the prospect of transfer to Rwanda must be a real one, which it is not easy to evade, which means the headline judgment on Rwanda's safety must be clear to all, subject, of course, as it should be, only to persuasive individual circumstances. And Mr. Deputy Speaker, I think that approach is worthy of support for two reasons. First, that illegal migration is a huge problem that the government must be able to pursue innovative solutions to, especially in the absence of credible alternatives. I give way to one of the
Fulton giving way, and he's making an excellent point about how we have to have innovative ways. Isn't it this the reason why other countries are looking at what the UK is doing? The likes of Austria, Germany and Italy have all talked about using third nations, because there needs to be a solution to this problem that he's so elegantly putting out.
I think one friend is right. I'm conscious, Mr. Deputy Speaker, not to trespass into second reading territory, but he's right about that. And of course, as our right honourable friend the Minister has pointed out, other international agencies also make use of Rwanda for these purposes. But the second reason that I think this approach is the appropriate one is that the judgments about the safety of Rwanda in the terms of the bill are ones which at this point Parliament is as able to make as any other body. And at this point, I should say I'm grateful for the information with which we have been provided, including the country information notice that was referred to earlier in the debate, which in my view supports the conclusion that Rwanda is safe for the purposes of the bill. But Parliament's decision-making, Mr. Deputy Speaker, on the safety of Rwanda must have integrity not just for now, but for the future too. And I am, I have to say, troubled by what I might describe as the absolutist, if not the eternalist nature of the wording of the bill. The bill says that Rwanda is safe and must be taken as such for a variety of purposes, and Parliament's judgment on that will stand, as far as I can see, until new legislation is passed. And that is why the Noble Lord Hope's amendments 2 and 3, are interesting. Now, I should say I cannot support them as they are, because they essentially transfer authority to the Treaties Monitoring Committee to determine whether Rwanda remains a safe country, based on the compliance or otherwise with the treaty. Now, I don't think that can be right, because the bill is intended specifically to give Parliament that authority, and Parliament should, in theory at least, retain the option to consider breaches of the treaty and nevertheless conclude that Rwanda remains a safe country for the purposes of the bill.
Well, my right honourable learned friend give way.
I give way.
I'm very grateful for my right honourable learned friend he makes a very powerful point, which I have much sympathy with myself. Isn't there something to be said for the government thinking between now and future stages in a way which might be capable of reconciling the legitimate concerns of Lord Hope's amendment, which is, I think, fair and honest, because facts change. And if Parliament sets itself up as an arbiter and decider on fact, it must have a means of changing its decision if the facts change, just as anything else would. Keynes comes to mind, I'd say to the Minister. Can we find a way forward on that?
My honourable learned friend anticipates my conclusion. I agree with him entirely. In fact, he in advance agrees with me entirely. But I'm conscious my honourable friend also wished to intervene.
For giving way. I was just keen to hear further on how he would see Parliament's role in assessing any future breaches of the treaty in light of what he has said.
Yes, I'm grateful, my friend. And essentially, it seems to me that Amendments 2 and 3, though, as I say, they are flawed, they do raise the valid issue of what happens if Rwanda at any point falls below the standards expected of it to justify safe country status. Now, the bill establishes in legislation the largely unchallengeable conclusion that Rwanda is a safe country for the purposes of the bill, because Parliament says so, without any mechanism for Parliament to say differently if the facts change, save, of course, presumably for fresh primary legislation. I give way to the Honourable.
I thank the Honourable Gentleman for giving way. What concerns me about what he's saying is, and I see almost two contradictions coming there. On a one level, the Honourable Member is saying about the sovereignty of Parliament, and then the issue about whether Rwanda is safe or not can be changed. But then we have a situation where our Supreme Court, the highest court in the land, said, after reading all the evidence, that Rwanda was not safe. And for Parliament, and yes, it is sovereign, but it's become almost a dictatorship, because it's a bit like saying a person A was found guilty in a criminal court, but because we here in Parliament don't like that, that person therefore must return back to court and be sentenced. And it's like, you know, using parliamentary sovereignty in the most nonsensical way.
I'm afraid I don't accept what the Honourable Lady says. First of all, and I think the Minister made this clear, the Government hasn't ignored the conclusions of the Supreme Court, which we must remind ourselves were in 2022. They have responded to those concerns, and new information is now available for Parliament to consider. And my point is that this is, on the Government's invitation, for Parliament to decide and to determine whether we consider that it is, on the evidence available to us, a safe country. We may all reach different conclusions about that. But the premise of this legislation is taking into account the concerns the Supreme Court have expressed. It is nonetheless for Parliament to determine whether Rwanda is a safe country or not for the purposes of this legislation. I simply say that for Parliament not to be able to say differently if the facts were to change, save for primary legislation, is simply not sensible. I think we all hope, perhaps expect, that Rwanda will remain a safe place for migrants to go. But if we could guarantee that indefinitely, we would not need the treaty the government worked so hard to secure, or the monitoring committee designed to scrutinise compliance with it. So it seems to me that although the government is entitled to reject the amendments before us today, it should give some thought to the situation that the bill is now in, breaking new ground to give Parliament specific authority over a judgment which will bind many, but which Parliament cannot easily revise, even if it comes to believe that revision is necessary. The treaty and the monitoring of its terms do provide a mechanism for Parliament to be alerted to significant changes in compliance, and I would ask my right honourable friend the Minister, and indeed his colleagues in the other place, to consider how Parliament may be given further scope to engage with this judgment if the need arises. Now, I do, Mr Deputy Speaker, appreciate the government itself retains means by which it can revise its judgment of the safety of Rwanda. But the government has, in this legislation, clearly and deliberately transferred the judgment on safety to Parliament. And if it's a judgment in Parliament's name, it must be right for Parliament to retain the capacity to reconsider it and, if necessary, to revise it.
Alison Thewlis.
Thank you very much, Mr Deputy Speaker. It remains the position of the SNP that this is an absolutely irredeemably awful bill. We do not support the Rwanda plan. We think it is both an offence to humanity and an absolutely egregious waste of public money, particularly at a time when many of our own constituents are struggling to feed themselves. But I thank the Lords for their work on this bill, for attempting at least to try and make this bill in some way better. And we would support all of the Lords' amendments to this bill for what they attempt to do with it. Looking first to Lord's Amendment 1, Lord Coker's amendment adding an amendment to comply with domestic and international law. Well, that really should be the very basic for any legislation coming forward in this place. It should abide by domestic and international law. It seems absolutely ludicrous that we have a bill coming in front of us that doesn't abide by international and domestic law. It's a bit of a cheek of the Minister to talk about Rwanda abiding by treaties when, and asking them to keep their loyalties to this treaty, while at the same time the Tories are going about the business of undermining the UK's own international commitments on some things that we in fact helped to draft ourselves in some of these international agreements. Things like the ECHR, the Refugee Convention, the International Covenant on Civil and Political Rights, the Council of Europe Convention on Action Against Trafficking, as well as customary international law. All of the and domestic laws, these are all things that we have created here that the government is set about undermining. It is absolutely ludicrous, and it would really brings into question the government's commitment to these international agreements, particularly to the Convention on Human Rights, which underpins so much. And we heard from honourable members earlier about the significance of some of this legislation to other things like the Good Friday Agreement, and indeed to Scotland's own devolution settlement. All of this the government seems fit to undermine by its actions.
Absolutely. I'm sure she will have read the report of the Joint Committee on Human Rights on this bill, and we noted that other nations may be influenced by the way in which the UK treats its international treaty obligations. And in particular, we noticed that the Prime Minister of Pakistan has referred to the UK's Rwandan policy in defence of his country's decision to expel from Pakistan hundreds of Afghans who had fled from the Taliban regime. Does she agree with me that that's most regrettable, that he should be able to refer to the UK's cavalier attitude towards international law to support his own cavalier attitude?
I absolutely agree with the point she's making here. And other countries around the world will be looking, have looked in the past to the UK as an upholder of rights, as a beacon of democracy and of human rights. And now, with this tawdry bill today, you can see how other countries are now looking at the UK's descent away from those international norms that they themselves set up. I'm going to make a little bit of progress because I'm mindful of what the Deputy Speaker said about time. I want to touch also on some of the misinformation that was put forward about Rwanda by the Minister and about UNHCR. Now, the transit agreements are not the same. Not the same at all as people being permanently relocated to Rwanda. And the UNHCR have mentioned that Norway, Sweden, Canada, France, Belgium, the Netherlands, Finland and the USA have taken people from those transit camps. So people have come from 10 countries, including Sudan and Cameroon, to Libya, to the transit camps in Rwanda, and are then being moved on somewhere else. They're not staying in Rwanda permanently, and indeed reports from that transit camp have highlighted that people have no desire to stay in Rwanda from those transit camps because of the conditions in which people are living. So it is not the same thing at all that the government is talking about here, and they should be absolutely clear on that and not mislead the House by things that suit their own arguments. Moving to Lord's Amendment 2, in the name of Lord Hope of Craighead, this is an amendment to ensure that Rwanda can only be designated as safe if the treaty is adhered to. And I think it's quite important here that we recognise, it says that this says it will be a safe country when and so long as the arrangements provided for in the Rwanda Treaty have been fully implemented and are being adhered to in practice. And some of the concerns of the Supreme Court on this matter was that Rwanda are not yet in the place where they can adhere to all of these things in practice. Perhaps they will in the future, but it is not safe now. To declare it completely safe in all circumstances right now is a false argument. And further, in Lord's Amendment 3, I think it's perfectly reasonable that I'm just going to make this point on Lord's Amendment 3, if she doesn't mind. I think it's perfectly reasonable that the government should come and report to Parliament on the terms of this treaty and how they're being monitored. What is the government afraid of? After all, if they think it's safe, if they think it's fine, why do they not want any scrutiny of this matter? Because it is indeed a situation that needs monitoring. There are continued reports of the Rwandan-backed M23 rebels and what they are doing on that country's borders. This legislation is a very poor way of setting safety. It's not flexible, it's not reasonable, it is not able to take account of changing circumstances. And sometimes those circumstances could change quite rapidly and quite unexpectedly, but yet we are legislating here to make Rwanda safe in all circumstances in perpetuity. That is clearly a ludicrous position, and it is a hostage to fortune, and the government should be aware of that. I will.
Away. She's making the point that things change with time. Does she accept that many things have been put in place both by the UK government and the Rwandan government since the judgment of the Supreme Court in the UK last year?
It's difficult to tell that because there isn't the scrutiny mechanisms in place to allow for committees of this House to ascertain if that is entirely the case. Now, I know my Honourable Friends Committee has been to visit Rwanda, has some information that she is hoping to share with that, as indeed I understand she has been on that trip as well. But that's not really good enough. There needs to be further continued scrutiny, and I think that is important that Parliament has the opportunity to do that. And I know from the Chair of the Home Affairs Select Committee that information, even information on this deal, has been difficult to come by. We had the debate last week in Parliament about the obfuscation and all the secrecy around the costs of the Rwanda plan. If this is how the government is beginning this journey, we have no confidence on this side of the House, certainly, that they cannot be trusted. So hence why this Lord's Amendment 3 is quite so important. There needs to be a scrutiny mechanism coming back to the House. I'm conscious of what the Deputy Speaker said around time, and I would like to make some progress here. Turning to Lord's Amendments 4, Lord Anderson of Ipswich talks about every decision maker must conclusively treat the Republic of Rwanda as a safe country, and amends this with unless presented with credible evidence to the contrary. And I think evidence is important. If you don't allow judges, decision makers to take decisions on the basis of evidence, merely on a bit of government legislation set in a small period of time, the government has absolutely zero credibility here at all. You're asking people to blindfold themselves to any other circumstances, to not hear any evidence, to not hear any proof that this is true. And I think that there must be the opportunity for every decision maker to treat to that evidence with the due diligence that we would all expect of that process. Moving to Lord's Amendment 5, this removes parts of the bill which state that Rwanda should automatically be considered a safe country and provide a rebuttal mechanism for the assertion of safety in Rwanda and liberty. See that this amendment corrects a deficiency in the bill whereby Parliament is asked to state that Rwanda is and will continue to be safe, and there is no mechanism by which this can be revisited. It's a moderate safeguard to put this in the bill, which the government should, if they actually thought about this any, would think this enhances the bill, but they are, of course, rejecting all amendments regardless of where they have come from. Moving to Lord's Amendment 6, this effectively restores the powers of the courts to make factual judgments in the safety of Rwanda for an individual case or for a group of people who share characteristics such as LGBTQ people. And I think it's quite telling that the government minister said that this completely undermines the purpose of the bill. Well, good is all I can say to that. They should be trying to undermine the purpose of this bill if the notion is to remove people such as LGBTQ people without allowing them to check the circumstances before they ship them off to a country that may not welcome them in all circumstances. I think it's perfectly reasonable that there should be the ability to make judgments of this case. And I recall when we looked, I think, at the illegal migration bill, there was a list of countries at the back of that bill which had exemptions for particular groups of people, even for men or for women, to those countries. This bill doesn't even do that. So I think it's quite reasonable that there should be some way of interrogating this power in the bill. Lord's Amendment 7 from Baroness Lister concerns age-related issues and unaccompanied children. And I think this is an issue actually of the utmost importance. The treaty makes provisions for what happens if a child somehow mysteriously ends up in Rwanda by mistake. Well, that mistake only happens because the Home Office has made some kind of error in sending them there in the first place. We know from hearing from medical professionals that some of the age assessment is effectively pseudoscience. We know that children who have come here, having crossed seas and continents and war zones through very difficult circumstances, well, of course, it might be more difficult. It might be more difficult to assess their age because they've had an awful lot of a tough paper round than my son, for example. And we know that not all children look exactly the same, present exactly the same, even though they may be the same age. We can all think of when we were at school, there was always some great big guy who had a beard and a hairy chest, when the rest of the people were just knee-high to a buttercup. This is perhaps the honourable member says not our convent school, but that's other questions, I suppose. But everybody is different. Everybody is different. You cannot reliably look at somebody and tell their age. And I think there needs to be more protections put into this bill to ensure that children who have already gone through incredibly traumatic experiences do not get sent to Rwanda. And this should certainly be within the bill here as well. Moving to Lord's Amendments 8, I'm conscious of what has said in time. I'm sure if she wants to come and make a speech on this later on this particular point, we will all listen to that. Moving to Lord's Amendment 8, this adds again a reporting mechanism to Parliament. Removals to Rwanda under the Illegal Migration Act 2023 within 60 days of the day on which this Act is passed. The Secretary of State must present laid before Parliament a statement. And I think this again is an important scrutiny mechanism. We should know in this Parliament who is being sent to Rwanda. We should know the timetable for those removals as this amendment suggests. And I think most importantly of this amendment, point C, is the arrangements in place for people who are not sent to Rwanda, because we know that only the tiniest of percentages of people who've ended up here will be sent to Rwanda. It's entirely unrealistic to suggest more than a few hundred people, if that, ever will get sent. So we need to know what happens to those people that end up in immigration limbo. Those people that are inadmissible. What happens to those people? Where are they? Who looks after them? Where do they live? How do they survive? What do they eat? We need to know what happens to the people that this government is committing to immigration limbo, because it is important, and I think the government should be updating Parliament. The Minister talked about publishing of immigration statistics. I think it needs to be more than that. This House needs to hold the government accountable for the people it sends, for the people that it doesn't send. And I think the point around the timetable of removals is also important, because I am aware, Mr Deputy Speaker, of people in Dungavel who are quite keen to leave the UK, and the UK government is taking an absolute age to arrange the mechanisms for them to do so. So even for people who want to leave and have reason to leave and go somewhere else, the government is not facilitating that at the moment. So the timetable for those removals is also quite important. And I think it was quite worrying that the Minister said that it is not necessary to report this to Parliament. I would disagree. It's entirely important and necessary to report this to Parliament so we can hold the government accountable. And again, if they think it's going to go so well, sure, they'll want to tell us how many people they've sent away, rather than those that they don't. Moving on to Lord's Amendment 9 on victims of modern slavery and human trafficking being removed without their consent. Now, this is a deep concern for many organisations within this sector who support people who have been trafficked and been through absolute hell. And I think it's very important that those people particularly are not removed to Rwanda without their consent. And I note that Redress have provided a particular briefing about torture in Rwanda. And that briefing highlights that there have been cases. Human Rights Watch, for example, their reports in Rwanda published in 2023, 2022, 2021, all include examples of torture. There's a list here in the Redress's briefing that I will not detain the House with, but I would urge all members to have a look at this. And in the Supreme Court case, they pointed out that evidence of human rights violations raises serious questions as to its compliance with Rwanda's international obligations, since this has occurred despite the country having ratified many international human rights agreements. And further to that, the BMA in their brief have raised their concerns about the ability of Rwanda to support those people that have been victims of torture, because they are indeed on the list of countries that is experiencing a healthcare worker crisis. They're on the list of countries that the UK is not supposed to recruit from. So again, that would call into question the ability of people there to be supported when they go. And medical reviews of 36 people under threat of Rwanda, removal to Rwanda have revealed that 26 of those displayed medical indicators of having been tortured, with 15 having symptoms or a diagnosis of PTSD, and 11 having experienced suicidal thoughts while in detention. These are an incredibly vulnerable group, and they deserve specific support. And I think it is important that we recognise this amendment, and that this amendment stays in the bill. Moving to Lord's Amendment 10, Lord Brown of Ladyston has added an amendment protecting supporters of the UK Armed Forces and their families from removal to Rwanda. And I think particularly in the context of Afghanistan that this is a significant amendment. And I've been in this House many, many times talking about the situation of Afghans who supported the UK's endeavours in Afghanistan and who have been quite despicably left behind. The Afghan triples, for example, I continue to get regular emails from a woman that served, was trained by UK forces, that worked alongside UK forces in Afghanistan, who is increasingly frustrated, terrified, worried, concerned, but most of all despondent. Despondent that the UK has let her down and has not maintained the promises that she felt that she had been made, and I will give way.
I thank the Honourable Lady for giving way. And on the point about the UK letting down people that actually were working for them and working with us, and this is all because of this gimmicky legislation which is designed to appeal to a certain percentage of votes, because this government has gone bankrupt of any real ideas about tackling the real issues that concern our country. This is just a gimmick legislation.
The Honourable Lady is absolutely correct. It is a gimmick. It has no basis, in fact, and there's a lot of doubt actually as to whether it will even work in the first place, but it appeals to a certain section that they think need to be appealed to. It's not so much a dog whistle as a foghorn, but it's definitely there. Continuing with the point around Afghans, the Migration Observatory at Oxford has pointed out that more Afghans have come by small boats than in any of the UK's schemes. And in fact, between the 1st of January and the 30th of June last year, 9 times as many Afghans arrived by small boats than on the routes the government specifically set up, because the ARAP and the ACRS schemes are failing to deal with this issue. They are supposed to be a safe and legal route that prevents people and dissuades people from getting in small boats. But in fact, they do not work. They take too long, they are inefficient, they do not provide the security that people require in order to come here. So they take things into their own hands. And really, Mr Deputy Speaker, who can blame them in the circumstances? Because I've seen too many cases, far too many cases in my own constituency. Now, when Afghanistan fell, we had around 80 people in touch who had relatives in Afghanistan, and I only know of a handful that managed to get their family over here, a handful. And that is despicable, and I worry about those people all the time. I don't know where they are. I don't know if their families even know where they are. But it is incredibly telling that there are so many people that will come by small boats because they cannot rely on UK government schemes to get them here safely. Mr Deputy Speaker, this bill is full of contradictions. It is a deterrent, but Rwanda is also safe. It undermines our own obligations internationally and our domestic courts while telling Rwanda that they must keep to theirs. It's not tough enough for the far right of the Tory party, and it's too harsh for the more reasonable wing. It is a circus. It is a deflection from a broken Home Office that can't even get the basics right. Yeah. Beset by delays, under investigation by the Information Commissioner's Office, wasting money, hand over fist. Mr Deputy Speaker, the Rwanda Bill is not Scotland's values. Scotland, we see the humanity in people. There is an alternative set out quite clearly in the Scottish Government's papers on this issue. We cannot trust the failed Westminster parties to dismantle the hostile environment that they created. Scotland must have the powers and we must have these powers urgently. We must have independence to play our part in the world.
I beg your pardon. Sir William Cash.
Mr Deputy Speaker, the government have proposed the rejection of Clause 1 Amendment, Motion 1, which I signed myself, and I'm very happy to support the government in the rejection of this amendment, this motion. The fact is that this amendment, this Lord's amendment, requires adding to the words in Clause 1, the words that the bill should include full compliance with international law and domestic law. Now, the problem here is, Mr. Deputy Speaker, that this is actually one of the most serious and dangerous clauses that I have seen in recent statutory history. It is actually contradicting one of the most fundamental principles of our constitutional law. We have, as my honourable friend, the Minister for Illegal Migration said, a dualist system. I've referred to this several times in the past, and it's absolutely fundamental. Unlike, for example, Germany, which Article 26 of its constitution states that international law is a fundamental, in fact, the most fundamental part of their constitutional arrangements. The clauses, Articles 65 and 66 of the Dutch Constitution has a similar provision. But we have a dualist system, and the sovereignty of our Parliament is absolutely imperative. And all the court cases, whether they are in the House of Lords or whether they're in the Supreme Court, over many, many generations, in fact going back, I would say, for centuries, makes it absolutely clear that where words are used in a statute which are clear and unambiguous, where the explicit intention of Parliament is clear, parliamentary sovereignty means that the supremacy of Parliament overrides and can override international law and should do so. The should do so is equally important. Indeed, I would go further and say that in our courts, sovereignty with those clear and unambiguous words trumps international law. And only, as I mentioned in an intervention on the Labour spokesman, the House of Lords Constitutional Committee, only a year ago, in paragraph 58 of its report on the rule of law, which included the likes of Lord Falkner, the noble Lord, Lord Falkner, Lord Robertson, and various others, and they clearly stated, and I'll quote from paragraph 58, parliamentary sovereignty means that Parliament can legislate contrary to the UK's obligations under international law. Now, that fundamentally disagrees with what is contained in the amendment that's come from the Lords. So what, if I may say, the heck is going on? Because the Lords had a very important decision to take and it's paragraphs, I think, 54 to 60 of that report, very carefully detailed reasoning which led them to that conclusion which I've just read out. And the further point, and I mentioned in a previous debate, the judgment of Lord Hoffman in a case called R versus Lyons. And I just want to quote from his judgment, because he says quite clearly that international law is trumped by the supremacy of law, the supremacy of sovereignty of Parliament. Parliament has to be the key determinant. And he says, and I'll just quote this again because it's so important. This is, I wouldn't bother doing this in this way if it were not for the fact that this amendment, and I am not sure whether the Leader of the Opposition really intends to achieve the objectives which are set out in Clause 1, And it does worry me very much indeed if he is complicit in this operation. The majority, it was a Labour amendment. It was led by 102 members of, a majority of 102 in the House of Lords. So we're going to have to take it seriously. And that therefore means we have to also deal with it seriously. And what he said was, English courts will not, and this is Lord Hoffman I'm quoting, English courts will not, unless the statute expressly so provides, be bound to give effect to interpretations of a treaty by an international court, even though the United Kingdom is bound by international law to do so. And he went on to say, the sovereign legislator in the United Kingdom is Parliament. If Parliament has plainly laid down the law, it is the duty of the courts to apply it, whether that would involve the Crown in breach of an international treaty or not. Nothing could be more explicit. Nothing could be clearer. But this amendment put forward by the House of Lords completely contradicts that principle because it combines in its wording both domestic law and international law as a matter of full compliance. In fact, I go so far as to say it is impossible in many circumstances to actually arrive at a point where there could be full compliance with domestic and international law according to our constitutional principles. I will give way.
I'm extremely grateful to the honourable gentleman who's making again a powerful argument about the sovereignty of Parliament, and he will understand why the sovereignty of Parliament is so fundamental. Because in a democratic policy, Parliament speaks for the people, given legitimacy by the people, and lawmakers here are answerable to the people. International obligations and treaties matter, but they don't matter more than the people's will.
Quite right. And I'm bound to say, with no disrespect to the noble lords, with a majority of 102 on this amendment, that they do have that legitimacy because constitutionally they are unelected. And that is also a fundamental point that needs to be taken into account. So this is they have a function to perform. They have a function to perform, but it is our intention, and it's the government's clear stated objective, to overturn this amendment. It goes much further and much deeper, in my opinion, than just the question of the Rwanda bill, but it is in the Rwanda bill, and I have to say I have never seen, in my 40 years in this place, or in my constitutional legal practice beforehand, any statute which purports to include words which are so all-embracing as these words that are used in their amendment. I do not know who devised the amendment, but I have to say that with a majority of 102, we had better look to our merits and make quite sure that we turn this amendment down. I'd also simply like to say this, that the question of the people who are behind it are internationalists, and this worries me too. There is a cohort of internationalists in the various government departments. I will mention the Home Office in particular and the Foreign Office. Being a mere backbencher, I am more than happy to castigate those who want to internationalise the sovereignty of our country. And I had a little bit of trouble, a local difficulty, as one might say, over our leaving the European Union, because these internationalists wanted us to be part and parcel of this great European Union, and I have never been happier in my life when on the 23rd of June 2016 we decided to reject these proposals, which I've been arguing for, shall we say, for a year or two. But having said that, I do want to say that the European Union itself is in a terrible bind over this question, and I haven't yet discovered what Germany is going to do about its own constitution in relation to the question of the global problem of illegal migration. And it's not just the European Union. It is also the United States of America. Day in, day out, we see the problems that they're facing on the Texas border. It's beyond imagination. They are really, the numbers of people who are flowing in and what they're trying to do about it raises all the same kind of questions which arise on the International Refugee Convention. So it's not just the United Kingdom. We are taking a stand, and I say to my honourable friend the Prime Minister, in supporting this rejection of this amendment, this is the way that we will enhance our reputation internationally by using our unwritten constitution to make it clear that what the people want and what the principles of common sense demand, that you just can't allow illegal migration to overtake your entire national interest. There is another point regarding the European Union, and that is, having been to Madrid for a COSAC summit as the British representative and chairman of the European Scrutiny Committee, and I'm going back again in a few weeks' time, I hope. And I have to say that the sheer consternation of the people at the last COSAC conference, which is comprised of the chairman of all the 27 member states, national European affairs or European scrutiny committees, that they were appalled at being faced with this legislation. And that is the proposals by a majority vote, that they would themselves have to accept quotas and compulsory fines if they were going to have any sensible arrangement in the European Union, which they can't have because it's inconsistent with their constitutional arrangements. It's inconsistent with the Charter of Fundamental Rights. That is why the issue of the European Convention of Human Rights, on which we need to focus in this particular context, and I don't need to make a speech about that because that would be outside the terms of this debate, and I'm not going to do it. But what I do say is this. I said to the wrote to the Prime Minister many weeks ago, in fact many months ago now, and I sent him a paper of 7 pages of breaches of international law by countries from all over the world, including the European Union, France, Denmark. There were so many of them, and it wasn't 7 pages of argument, it was 7 pages, each line of which contained breaches of international law by the legion. So what are we worrying about? Get on with it. Make sure that we reject this amendment and don't allow the Lords, if they come back on ping pong again, to think that they're going to get away with it. We want to be very firm about this. We have a dualist system. We have a sovereignty of Parliament. We have an elected Parliament. We have our voters' wishes to take into account, and we should stick by them and do nothing else.
Dame Diana Johnson.
Thank you, Mr. Deputy Speaker. It's almost 2 years ago since the Rwanda scheme was first announced by the then Home Secretary in April 2022. And this is now the 3rd piece of legislation connected with that scheme. And when this bill had its second reading in the Commons at the end of last year, I noted that the challenges of stopping dangerous boat crossings is real, and one, despite what the Minister says from the front bench, is one that I think every member in this House wishes to address. The Home Affairs Select Committee's report on channel crossings made it clear that there's no magical single solution to dealing with irregular migration. Instead, our report stated that the best solutions are detailed, evidence-driven, fully costed and fully tested policies, achieving incremental change, as well as the need for close cooperation with international partners. These remarks are still relevant, and it's interesting to note the new tone of the Home Secretary, that this policy on Rwanda is now only a part of the solution to small boat crossings, but as we know, it's a very expensive and is using up a huge amount of time in this place and a great deal of political capital. In the absence of any pre-existing evidence that the UK-Rwanda partnership will deliver on its primary objective to deter small boat crossings, the need for careful, considered and responsible planning and lawmaking is even more acute, which is what the amendments under consideration today seek to address. Turning to the amendments in turn, and I just want to remember that the Lords, as a revising chamber, have an important job to do to scrutinise legislation, to improve it where necessary, and I think it is helpful for this House then to see what improvements the other place are suggesting to legislation from this place. Amendment 1 adds a requirement to maintain full compliance with domestic and international law. And I note that the Minister today and the Government Minister in the other place argued that the bill was already compliant with the rule of law and that it was predicated on compliance with international law in the form of the treaty, commenting that the treaty sets out the international legal commitments that the United Kingdom and the Rwandan governments have made, consistent with their shared standards associated with asylum and refugee protection. Now, this is the same treaty that on the 22nd of January the House of Lords agreed a motion not to ratify. And it is for the same treaty that this government refused to allow time for members of this House to debate and reach a view on it, despite a request from the Home Affairs Select Committee. Now, the time period for objections is over and the government can ratify the treaty as long as they lay a statement setting out why they're doing so despite the decision of the Lords. So if the government wanted us to accept their assurances that the treaty is itself evidence of compliance with international law, they should really have given this House the opportunity to debate that treaty. And in the absence of such, Amendment 1 would provide reassurance of compliance with domestic and international law, as criteria the government insists the treaty and bill already satisfy. It stands to reason that there shouldn't really be any issue with that amendment. I'm going to carry on. The Honourable Gentleman spoke at length and I do want to get through a number of amendments. Turning to Amendments 2 and 3, which also relate to the treaty, the noble Lord Hope in the other place argued that Rwanda being declared a safe country should be dependent on the arrangements provided for in the treaty being fully implemented and being adhered to in practice, with Amendment 3 setting out what that would actually look like and giving the Independent Monitoring Committee a significant role in reporting on this. In response, the Minister and the Lords set out that the government would only ratify the treaty once we agree with Rwanda that all necessary implementation is in place. And as we know, the bill will only come into force once the treaty has been ratified. Here again, it would have been helpful and a benefit to this House to have had the opportunity to debate that treaty. Yet scrutiny of its provisions in the Commons didn't happen, just as financial details of the UK-Rwanda partnership have been held back from Parliament until very recently. As highlighted in last week's Estimates Day debate on asylum and migration, the Home Office repeatedly refused the Home Affairs Select Committee requests for basic financial information about the scheme, only disclosing some of the costs after our committee joined forces with the Public Accounts Committee to request a National Audit Office investigation into the costs of the scheme. We now know the core costs are very expensive. 370 million for the Economic Transformation and Integration Fund, an additional 20,000 per individual relocated, a further 120 million once 300 people have been relocated, and £150,874 for each individual relocated to Rwanda on top of all of that. Direct costs to the Home Office of 28 million by the end of 23-24, 1 million per year in staff costs, and 11,000 per individual relocated for the flight costs. And I still don't actually know whether the Home Office have an airline that they've been able to enter into a contract with to deliver the removals to Rwanda. Crucially, though, we still haven't been told what the costs are for implementing the provisions in the treaty, such as a new asylum appeals body. Is the money available and allocated to pay for that? And we already know that the Home Office budget is under acute pressure. On the 1st of February this year, the Home Secretary requested an emergency drawdown of 2.6 billion from the reserves because the department had run out of money before the supplementary estimates had been approved. So with serious questions still to answer about how the government will fund the implementation of the treaty, as well as the practical implementation of the treaty, I believe that these amendments, again, help provide some necessary assurances that the government has hitherto failed to provide to Parliament. Next, Amendments 4 and 5 would make it possible to argue that Rwanda is not a safe country on presentation of credible evidence to the contrary, and would allow appeals to be brought on that basis. Responding on behalf of the government, the Minister in the Lord said, "We've been clear that the purpose of this legislation is to stop the boats, and to do that we must create a deterrent that shows that if you enter the UK legally, you will not be able to stay." Now, on the Home Affairs Select Committee, we've repeatedly asked both ministers and senior officials what evidence there is for the deterrent effect of the Rwanda scheme. The Permanent Secretary, Sir Matthew Rycroft, required a ministerial direction for the Rwanda scheme because there wasn't the evidence that it would be value for money. When he gave evidence before the committee last year, he said that this was because the value for money judgment depends on the amount of deterrence that the policy will produce. He noted that while numbers of people crossing the channel were falling, it is very hard to tell how much of that is the possibility of being relocated to Rwanda, particularly, as you suggest, before the first flight to Rwanda has actually taken off. The truth is that we actually don't have any idea whether the policy that this bill facilitates will indeed have the deterrent effect that the Minister cites. And as I've highlighted during the Committee of the Whole House, it does not seem sensible for the government to propose that the status of Rwanda as a safe country should be fixed forevermore, which would, by extension, make Rwanda the only country on earth in which nothing ever happens or changes. Amendments enabling the presentation of evidence relating to these changes and their implications for safety in Rwanda therefore seem eminently reasonable and indeed necessary. Amendment 6 deletes Clause 4 and introduces a new clause into the bill, allowing much wider grounds for legal challenge. The Home Affairs Select Committee has always recognised that appropriate legal challenge is a necessary part of any functioning asylum system. Amendment 7 disapplies Section 57 of the Illegal Migration Act 2023, meaning that people claiming to be children could appeal against a decision that they are over 18. The Noble Baroness Lister, who tabled the amendment, explained that it was intended to minimise the risk of any unaccompanied child being sent to Rwanda. During the committee's Channel Crossings inquiry, we heard multiple examples of safeguarding processes failing across various parts of the asylum system, including cases of children being mistaken for adults. Section 57 of the Illegal Migration Act refers to the process of age assessment in the Nationality and Borders Act 2022. The committee's Channel Crossings report noted that the Nationality and Borders Act 22 contains a number of provisions relating to age assessment, including a new National Age Assessment Board and powers for the Home Secretary to make regulations specifying scientific methods for age assessments. The report notes that the provisions are controversial because there is a broad consensus that age assessments should not rely exclusively, or for some stakeholders at all, on analysis of the skeleton or the teeth. Yeah. And I am concerned that without the amendment tabled by Baroness Lister, this could produce a child wrongly assessed as being an adult being sent to Rwanda. I'm going to carry on because I want other members to be able to speak. Amendment 8 relates to the timetable for removals under the Illegal Migration Act 2023. It would require the Home Secretary to lay before Parliament a statement setting out all the individuals whose asylum claims have been deemed inadmissible since the Act received royal assent. The statement would have to include the number of individuals due to be removed to Rwanda and the timetable for those removals, as well as the arrangements for those individuals not being removed to Rwanda. Now again, this is information that the Home Affairs Select Committee has already tried to glean from the Home Office. Indeed, I asked the Home Secretary when he appeared before the committee in January how many individuals whose asylum claims had been deemed inadmissible since the Illegal Migration Act received royal assent would be sent to Rwanda. And he replied that that will depend on which other countries we have return agreements with. Despite pressing him several times on this point, our attempts to ascertain any further information were unsuccessful. And as the Noble Lord Coker said in moving his amendment, this is a subject on which it would be good to have some facts, and it's why his amendment has significant merit. Well, if the Honourable Lady is trying, yes, I will on that, but I am keen to finish.
Wait, because it was a similar point that I was hoping to intervene on the lady from the SNB Glasgow earlier, because when it comes to facts, I am concerned that these are slightly selective, particularly in relation to age assessment. It is the case that in their Lord's House, the evidence that was brought before their lordships was, as the Honourable Lady will know only so well, that the expert committee in relation to age assessment that is independent, has been set up independently, has proposed, the AESAC has proposed, that accuracy will be improved in age assessment in multiple ways by age assessment, or not just of one biological method, but by assessing a range of methods alongside the existing one. So I am concerned that there is a very partial evidence being presented in the debate today about age assessment, and I'd be very grateful for her confirmation that she does support the inclusion of these important methods of age assessment that the committee has recommended in order to support the correct age assessment for safeguarding children.
Well, very briefly, I'm reporting on what the Home Affairs Select Committee, cross-party, has decided and put in our report on the cross-channel small boats. We produced it, now it's getting on for 2 years because this matter has been going on for some time. I'm reporting of our concerns, which are widely shared amongst all members of the committee, about the problems, and it is a very difficult thing to assess the correct age of someone who is claiming to be a child. So I think it's just worth reflecting on. This is not an easy thing to do, and the Home Affairs Select Committee is mindful and concerned about it. I also just want to say to the Minister that I think it would be very helpful in his comments if he's able to give a little bit more information about the stories which seem to be circulating widely in terms of the number of individuals who might well be sent to Rwanda if the bill is given royal assent. The story now seems to be 150 will be travelling to Rwanda, but there will be a pause and that it will be a staggered process. It would be very helpful to understand that. It would also be very helpful to understand how that fits with the context of the thousands who have already been deemed to be inadmissible for the asylum system, and also the voluntary nature of the scheme, which again is being reported widely in the press, of people being offered £3,000 to travel to Rwanda. This is all information that seems to be widely circulated in the press, but it's not information that this House seems to be given by ministers, and the Home Affairs Select Committee certainly hasn't received any information about this. I also just want to say again, as I said on Thursday, it's rather regrettable that we can't have access to information, financial information and practical information about how schemes are going to work, and that we have to repeatedly ask and ask and ask to get basic information to allow us to make a view or come to a view about the proposals the government are bringing forward. The Home Office say they're very keen on scrutiny. Well, I have to say, as the chair of the Home Affairs Select Committee, that's not certainly been my experience over the last few years. They do not want scrutiny, and any attempt to obtain information is rebuffed. I want to turn to Amendment 9, and again, Amendment 9 is tabled by the noble Baroness Butler-Sloss, who is a formidable character who has fought for years around the issue of modern slavery. And I think if she is tabling clauses to this bill, it does us all well to look very carefully at what she's saying. In that new clause to the bill, She wants to create an exception relating to the removal of victims of modern slavery and human trafficking. The new clause states that a person with a positive reasonable grounds decision from the National Referral Mechanism must not be removed to Rwanda until they have received a conclusive grounds decision, and that a person with a positive conclusive grounds decision must not be removed without the decision maker considering the effect on their physical and mental health or safety. Now, the Home Affairs Select Committee recently produced our report on human trafficking, in which we expressed our concern that the government is prioritising irregular migration issues at the expense of tackling human trafficking. Human trafficking is not an immigration offence, but an exploitation offence, and the two things must not be conflated. People should not have to choose between continuing to be exploited or risking deportation to Rwanda. A point made very forcefully to us by the former Prime Minister, the Right Honourable Member for Maidenhead, and it is why I believe this amendment has merit. Amendment 10, tabled by the Noble Lord Brown, would provide an exemption for people who supported the armed forces overseas or who have otherwise been agents or allies of the UK overseas. It's clear to me that the fact that when you look at the composition of those who are travelling in small boats, the top group travelling in small boats are from Afghanistan, 20%. And I think it's well worth considering why, when we have schemes that have been set up to facilitate people arriving from Afghanistan, that people are travelling in those small boats. So to conclude, the Lord's amendments go some way to addressing concerns that the Home Affairs Select Committee has identified in relation to the Rwanda scheme, and I think should be given serious consideration by the government. And I am disappointed that the Minister has been so dismissive of the genuine reasons why these amendments have been tabled. In terms of the effective parliamentary scrutiny, the means by which the government has sought parliamentary approval for this bill and its associated treaty, I would say I don't think that's been very satisfactory, with the debate denied on the treaty and crucial information being denied and rejected for months on end. To stop the small boats and make the asylum system fit for purpose, we need an evidence-based approach, informed and strengthened by parliamentary scrutiny, something that I think sadly has been limited by the passage of this bill.
Point of order, Sir William Cash.
I don't want to seem churlish in any way, but the Honourable Lady refused to accept an intervention from me on the grounds that I was actually talking for too long. She just managed to exceed my speech by 5 minutes.
Order. I have to say to the honourable gentleman, that's not even a nice try. Alexander Stafford.
Thank you very much indeed, Mr Deputy Speaker, and it's a pleasure to speak on this very important debate on a very important matter, and that is obviously to get this bill through Parliament, to get the flights off to Rwanda, to get those wheels down Kigali, and make sure that we defeat these awful amendments coming from the House of Lords. Now, the Labour spokesperson from Front Bench claimed that these amendments, their support of the amendments, were there not to wreck the bill, but actually to help the bill along and actually to make the bill better. Yet we also heard from the spokesman from the SNP bench that they wanted to upset the bill and made it clear. And to me, these bills are clearly wrecking amendments. There's no ifs, no buts about it. Now, the Honourable Member, the Right Honourable Member from Stone, made it clear when he talked about rejecting Amendment 1 that the dangerous precedent that it sets, not just for this bill, but for all bills, about the supremacy and primacy of this House. And that is, I think, the first thing we need to properly reflect on. This Parliament is sovereign. This body, the House of Commons, is sovereign. And by taking that sovereignty away from us, we are upsetting everything. Now, the amendment talks about compliance with the rule of law. Now, how can it be against the rule of law when the democratically elected body of this House wants something, the free and independent sovereign country that is Rwanda wants something? We are actually, by rejecting this amendment, enhancing our sovereignty and our bill. It is clear and needed. But why is it needed? Why are this bill so needed? And why is it essential that we stop these wrecking amendments? That is because for far too long we've got far too many illegal immigrants coming into our country. These illegal immigrants who are jumping the queue, going outside the rules and regulations of how they should be coming to our country, are just making it harder and harder for people in this country. This bill is necessary, needed and proportional. These illegal immigrants are putting huge strain on public services. They're putting huge strains on things that everyday people use: doctors, GP services, schools. The human cost when people are killed, unfortunately, travelling crossing the channel, need to be stopped. The financial cost on top to residents in Rwanda Valley and across of our areas need to be curtailed. And these amendments try and wreck the bill. And this is why we need to actually double down on this bill. Now, we have a lot of debate already, for some reason, about how many people are going to go to Rwanda, and clearly this is out of scope of the bill, but so many colleagues on the other side of the benches have mentioned this. We've had some numbers of like 100 or a handful. I surely hope that it's going to be in their thousands and tens of thousands to get rid of the backlog and stop the illegal immigrants coming here. Because fundamentally, this is the point of this bill, is to stop the illegal immigrants coming here. And any attempt to wreck this bill is an open door policy to let human traffickers traffic people illegally into our country, to upset our local communities, and ultimately, unfortunately, more people will die if this bill doesn't go through because of the loss of life in the Channel. No one has yet really talked about the deterrent factor of this bill. A similar bill, a similar process did work in Australia, where the illegal immigrant situation rapidly decreased because of the deterrent effect. And it's important that we do reflect on that deterrent effect. Because if we stop people coming here in the first place, we are going to save lives and we are going to save money. It's so important that we get them through.
My honourable refers to the Australian system, which was known as Operation Sovereign Borders. Of course, it is true that the offshore processing that Australia enjoyed was only part of the solution. That's always been acknowledged by the government. Rwanda isn't a be-all and end-all, but it's a critical part of our policy, as it was in Australia. And I just wonder if you might comment on this. It seems to me that either the House of Lords is careless about the threat of our borders being breached with impunity, or clueless. They don't know it's happening. Which do you think it is, clueless or careless?
I thank the honourable member for his comment. I wouldn't want to comment on what necessarily is going on in their lordships' minds, but what is going on in their lordships' mind clearly is not caring about the average person in Rwanda Valley. The concern they have when I knock on the doors about the high levels of illegal immigration. They clearly don't care about the people who are dying in the Channel trying to cross it. They clearly don't care about the cost to the public purse of these hundreds of thousands of illegal immigrants coming over here. Their lordships clearly do not care about the everyday person on the street, and their lordships ultimately are not answerable to the democrats elected people, and we are, and that is the crucial point. We are the voice of the people, we are answerable to the electorate, we are answerable to our constituents, and we need to get this stopped. And there's so much more of these amendments that are upsetting and disrupting the bill, so I'm going to touch on a few more of them. And the first one, obviously, we want to talk about Lords Amendments 4 and 5, talking about whether Rwanda is a safe country. And I would be very careful about some of the words used by the other side of the House to describe Rwanda, because fundamentally Rwanda is a safe country. Not only are we declaring it in this House, but it is patently true. And to say that Rwanda isn't safe is a fundamentally sort of colonialist attitude to other parts of the country. Because otherwise we are actually saying to other country, your country isn't safe, your country is not good enough. We are on this side saying Rwanda is safe. It is good, Molo. The 1.4 million tourists who went to Rwanda last year, of course I'll give away, of course.
If Rwanda is such a wonderful place to be deported to, why would the prospect of being deported there be a deterrent?
It's an interesting point. Now, I'm under no illusion that Rwanda is a great country. But I'll tell you a country that's even better than Rwanda, and that's Britain. That's the United Kingdom. So of course they want to come to Britain, because we are a better country. Doesn't say Rwanda isn't safe. Doesn't say Rwanda shouldn't be safe. So by looking at Lord's Amendments 4 and 5, the government has already completed a detailed assessment that Rwanda is a safe country. We need to accept the facts of that assessment and start to take even more action while the boat crossings are low. And they are low. They were down 36% last year, like my honourable friend just mentioned, because of the other stuff we're doing as well, such as the Albanian deal, which is working, such as stopping the physical boats getting to the sources. Of course.
I'm grateful to Honourable Member for giving way. Would he also agree with me there is another safe country, which is France?
I thank the Honourable Lady Giveaway. She does so much work in her constituency on this issue. Indeed, France is a very safe country, as is Spain, as is Italy, as is Germany, as is so many countries. These illegal immigrants cross to get to, and they should be claiming asylum in the first safest country. They have no duty or right to come over this way, but we do have a right and duty to protect our country, protect our borders, protect our sovereignty and protect our people. And that is why we need to have a clear idea of who's coming here and make sure that we can deport people that we don't want or don't need and process them elsewhere. Now, back to, obviously, Amendments 4 and 5. Now, we cannot allow these individuals to challenge their removal grounds on the fact that Rwanda is not a safe country. We in the UK government have the assessment, and we cannot allow the amendment for individuals to challenge their removal grounds. New international treaties mean that our decision cannot be second-guessed, and that is vital in moving forward with this legislation. Now, I also disagree with Lord's Amendments 6 and 9, as Rwanda has its own safeguarding system to ensure that the safety of those individuals will be relocated to Rwanda. Now, if we start questioning each claim and question whether to send them to Rwanda, we're adhering to the ideas that Rwanda, once again, is not a safe country, which contradicts the safeguarding processes Rwanda has already introduced. We have already identified Rwanda as a safe country, so it should not be up for interpretation based on an individual's claim they cannot be sent there. I also disagree with the last Lord's Amendment that this can be incorrectly favour those individuals who want to abuse our immigration system. We need to ensure robust measures are implemented to ensure that the Rwanda plan is executed with efficiency to present those who want to play the system. We need to ensure that this is the toughest legislation ever, and we need to do everything it does to prevent individuals from personating children to bypass the Rwanda scheme. Now, we've already had some discussions about checks on whether people are children or not, but in order to protect children, we need to make sure who children are or not. And there are safe, independent ways of verifying the age of people. And that goes on in other countries as well. I believe Germany and maybe France also do take out similar process. And I don't think any of us are claiming France or Germany isn't a safe country. And if it's good for them, it's good for us. We've already heard about how actually Germany and France's legislation is different to ours. But if they can have these checks on children or not, we should be having those checks, because it safeguards British people, but also safeguards those genuine child refugees as well, to make sure they're not put in a very awful situation as well. I will always...
I'm extremely grateful for giving way on 2 occasions. You will remember that when we were debating an earlier piece of legislation, in discussion with the then Minister, the Right Honourable Member for Newark, this issue of age verification was raised. He's right indeed that other countries use it. And on that occasion, that Right Honourable Member explained why it is so important. Because the oldest so-called asylum seeker found to be here was found claiming to be a child, turned out to be 42 years of age.
I thank my honourable friend for that apposite interjection, and that is the concern. When you've got a situation when some people claim their children and they're 42 years old, that is not good for anyone. That is not good for any of the scheme. And he also mentioned the fact, a previous time we looked at this bill. Now, we've been debating this bill for coming up to 2 years now in one shape or form, or rather the scheme to Rwanda for 2 years. And again, in every step, the members on the opposite benches are wrecking and putting absolutely every objection to it. And these amendments being the latest objections to it. Briefly, of course.
Very brief. Just in terms of age verification and opposition positions, would he share my concern that the SNP actually objected to the regulations on age verification, and the Labour Party did not vote in the regulations, having to be carried by the Conservative votes? That's correct.
Well, I thank the honourable member for that, and that is a shocking thing to say, absolutely shocking. I mean, it really does care where the safeguarding of children actually lies. They actually lies. And obviously, as a Member of Parliament representing Rotherham constituency rather, we know what Labour thinks when it comes to safeguarding our girls in Rotherham. But we should be able to look after everyone, and this bill will actually make sure that we look after the people in Britain, give sovereignty to our our people and control of our borders. I think we've had 2 years now of dither, delay, wrecking amendments, planes not taking off, people being pulled off planes, and people in members in the opposite benches trying everything possible to stop this well-needed, well-liked, well-supported policy going ahead. And I think any people trying to support these amendments are no better than the people who want to wreck the bill of an open-door policy. And I say to all members in this House, we must reject the Lord's amendments, we must stand up for Britain, we must stand up for sovereignty, and we must get wheels down in Kigali as soon as possible.
Joanne Cherry.
Thank you, Mr Deputy Speaker. I rise to give my support to these amendments. I'm supporting Amendments 9 and 10 because I think they are basic humanitarian amendments designed to exempt from the process of being sent to Rwanda the victims of modern slavery and human trafficking. And also our agents or allies and people who supported His Majesty's Armed Forces overseas and persons who have been employed or indirectly contracted to provide services to the UK. I think it would be shameful if this House did not support those amendments. But I want to direct most of what I'm going to say to Lord's Amendments numbers 1 to 6, because these, number 1 relates to whether or not the bill is fully compliant with the rule of law, but 2 to 6 broadly deal with the issue of the safety of Rwanda. And I think has been adverted to earlier in the debate. Last month I visited Rwanda as part of a delegation of the Joint Committee on Human Rights, and we're going to be reporting on due course on our findings as part of our inquiry into the human rights of asylum seekers. So although I'm chair of the committee, anything I say today are comments I'm making in a personal capacity because the committee has not yet deliberated. But I am very firmly of the view that Rwanda cannot be described as a safe country for the United Kingdom to send asylum seekers who come to our door, based both on what I observed there, but also based on objective evidence about such arrangements as presently exist in Rwanda for asylum seekers, not refugees on their borders, but asylum seekers. The degree of expertise amongst their immigration officers, the degree of expertise amongst their lawyers and judiciary, and crucially, evidence the Joint Committee on Human Rights has received about the state of human rights in Rwanda, and perhaps most importantly, the information I referred to in an earlier intervention collated by the Home Office about the state of human rights in Rwanda, and I'll come on to that in a moment. But when we were in Rwanda, we met with many government officials and organisations, most of whom meet with government approval, and naturally they had a good story to tell us. And like the Supreme Court, I believe that they're in good faith. But we need to weigh that against the evidence of what we have heard from others, and also the evidence collated by the Home Office about human rights abuses in Rwanda, and also a recognition of how long it is going to take Rwanda to put in place the arrangements required by the fresh treaty and for them to bed down. And in connection with that, I would remind members of this House what the House of Lords International Agreements Committee said when it undertook its scrutiny of the new treaty in January. It said, while the treaty might in time provide the basis for an assessment of Rwanda as a safe country, if rigorously implemented, as things stand, the arrangements it provides for are incomplete, and a significant number of further legal and practical steps are required under the treaty, which will take time. And the House of Lords International Committee listed those, and they said the arrangements put in place by the treaty will also need time to bed in, to demonstrate that they operate in practice. The Home Office has been unable to offer any clear timeline for implementation, but we, the House of Lords International Agreements Committee, agree with the evidence we received that the treaty is unlikely to change the position in Rwanda in the short to medium term. And let me just develop this point and then I'll take some interventions, because I agree with the House of Lords on that. And it fits with what I observed on the ground in Rwanda, which I'm going to come on to. But perhaps most importantly, because an honourable member who's no longer in his place earlier referred to what he described as the views of UNHCR. When I met with UNHCR on the ground in Rwanda, they said, and I quote, We still don't believe that Rwanda is a safe country for asylum seekers. It will take systemic and structural change to happen first, and then that change will need to cascade through the system. That will take time. I also believe that a greater commitment to meaningful human rights protection is also required. I'll take this intervention first, and I'll come to my honourable.
The honourable lady is making, as she usually does, a considered argument based also on her visit to Rwanda. I haven't been there, but I wonder if she's mindful in making that argument that previously both the United Nations and the EU have designated Rwanda as a suitable place to accept refugees. What does she make of that?
Is this. The Rwandans host over 100,000 refugees on their border who've come over from neighbouring countries like Burundi and the Congo because of conflict in those countries. They are people from neighbouring countries who have the ambition to go back to their own country as soon as they can, and they live in refugee camps on the border. They're a completely different category from asylum seekers who've sought to come to the UK and then are going to be sent to Rwanda. That's not just my view, that was the view of the UNHCR. And I'll give way to my honourable friend who's a member of the committee.
I thank the lady for making way. I was also in that meeting with the UNHCR, and isn't it also true that when we questioned them about their motivation for why they felt that we shouldn't be sending our asylum seekers there for processing, they were very clear that they said it was because they felt we were shirking our responsibility, that we should be taking all those asylum seekers, that we had the capacity to. And isn't it also true that in that meeting, they said they agreed that they based their emergency transit base there, that they sponsor scholarships in Rwandan universities for refugees, and that it is a very safe place. In fact, I'm going to quote from my notes that I said, so it's nothing to do with safety, it is because you feel we should be doing this ourselves, and they said yes.
Detailed notes of our meeting with the UNHCR. Now, I think the honourable lady is right to say that the UNHCR said quite clearly that they think the United Kingdom is shirking its responsibilities, and actually so do I. That's my personal belief. And I base that on the number of refugees in the world. There's over 100 million displaced people in the world. There's over 36 million refugees. Really quite a small number of them make their ways to the shores of the United Kingdom. There's going to be a hell of a lot more in the years to come because of climate change. And quite frankly, my very firm belief is the United Kingdom needs to shoulder its responsibilities as one of the richer countries in the world, rather than shuffling them off onto a country like Rwanda, which, as we saw, has come great strides. But it really can't be compared to the United Kingdom in terms of its wealth. A little bit more about my views on why I don't believe Rwanda can yet be described as a safe country. I mentioned earlier in an intervention that it's very important to read the United Kingdom Supreme Court judgment in its entirety, because if one does that, and particularly I'm referring to paragraphs 75 to 105, their decision was based on a number of things: evidence about the general human rights situation in Rwanda, the adequacy of Rwanda's current asylum system, and Rwanda's failure to meet their obligations in a similar agreement regarding asylum seekers with Israel in 2013. So there was a lot to the judgment. It's very rich in detail. They'd considered a lot of evidence over a long period of time. It's just really not an adequate acknowledgement of the exercise in which the Supreme Court was engaged to simply say that a few months later an Act of Parliament can change the reality on the ground and solve all the legitimate concerns that the Supreme Court had about the situation in Rwanda. Now, yes, the United Kingdom government have entered into a new agreement, but as I said earlier, the trouble is that none of the new measures to which Rwanda and the UK have agreed are yet properly in place. So the UK government's insistent that Rwanda has miraculously, since the Supreme Court's considered judgment last year, become a safe country for asylum seekers. That can only be described as a legal fiction. And nothing I saw on the ground in Kigali led me to doubt this. When we were there, the relevant legislation was still going through the Parliament. The legal reforms and the new systems agreed had yet to be put in place, and although training had commenced, it was still very much in its infancy. Now, the Supreme Court found that the Rwandans were acting in good faith, but that, and I quote, intentions and aspirations do not necessarily correspond to reality. And having spent some time in Rwanda and met with Rwandan government officials, healthcare workers, ministers, lawyers, those who will deliver the legal training, the National Human Rights Commission and NGOs, I think the Supreme Court got it right. I think the Rwandans are in good faith, but I don't think that intentions and aspirations correspond to reality. It's a very interesting fact, Mr. Deputy Speaker, that owing to their recent history, we heard that 80% of Rwandans have themselves been refugees. And as I said, on their borders, they accommodate well over 100,000 refugees and displaced persons from neighbouring countries. The Rwandans I met, many of them were at pains to emphasise to me that they see refugees as their friends, their brothers and their sisters. And I was very struck by how their attitude contrasts with the UK government's hostility towards asylum seekers and the UK government's desire to offload both their legal and, I believe, their moral responsibilities to asylum seekers onto others. Now, when the Joint Committee on Human Rights considered the UK government's original agreement with Rwanda and the illegal migration bill, we expressed concern that the policy could be seen as an outsourcing of the UK's own obligations under the Refugee Convention to another country. I know not everyone will agree with that, but I think if you look at the number of displaced persons and refugees in the world, compared to the tiny fraction that we take, I think we are not living up to our moral obligations, and clearly there's a legal argument that we're not living up to our legal obligations either. I will in a moment. The Joint Committee on Human Rights also said, back when we considered the original agreement with Rwanda and the illegal migration bill, that removing asylum seekers to a state where they face a real risk of serious human rights abuses or of being sent on to a dangerous third country as a result of an inadequate asylum system is inconsistent with the UK's human rights obligations. That I give way to my honourable friend who was also on the visit to Rwanda, to Kigali.
Thank my honourable friend for giving way. She says that she believes that the UK is taking a tiny number of refugees and asylum seekers. I'm not sure that that's true, but I'm interested to know what she would consider a reasonable number, or whether she believes there is.
Well, I don't have time to get into redesigning the system, but during our inquiry, the committee has, as the Honourable Lady will recall, heard very detailed evidence about what might be a reasonable number, about how the number we compare the number we take compares to the number of refugees in the world. We heard very detailed evidence from the CEO of the Refugee Council, Enver Solomon, about what might be a compassionate but also a reasonable way for the United Kingdom to approach its moral and legal obligations. But I want to focus back on why I am supporting the amendments which relate to the lack of a safe situation in Rwanda. Many of those I met in Rwanda were very keen to emphasise that their written constitution contains good human rights protections. And if you look at it, it does actually. But few of them were able to point to any case law showing people in Rwanda taking advantage of those protections, as we are, at least for the time being, Mr. Deputy Speaker, able to do in this country in our courts. And I also found out when I was in Rwanda that in 2016, the Rwandan government withdrew the right of individual petition to the African Court of Human Rights because they were unhappy with the way in which it handled claims brought by Rwandan dissidents. I couldn't help but see an echo in this of the UK government's attitude towards the European Court of Human Rights when it makes decisions that it doesn't like. But on the evidence about human rights concerns in Rwanda, as I said in an earlier intervention, the Home Office have compiled a 137-page document, a country information note on human rights in Rwanda, collating sources ranging from the US State Department to Human Rights Watch, setting out serious shortcomings in the protection of human rights in Rwanda. Now, I asked the Minister who's in his place about this. He seemed very reluctant to engage with this, but I hope he's going to come back to it. How does he reconcile his repeated, and his colleagues' repeated insistence that Rwanda is a safe country with a 137-page document issued by his own government and updated in January of this year. It sets out how it collates the evidence, and it says it tries to take things only from reliable sources. And of course, one of the biggest sources in the document is the US State Department, of one of our major allies. Yes, sir. Give it away.
Would there not be some sense in allowing Home Office decision makers to take account of the Home Office evidence that's been gathered together in the way that she describes?
Yes, I only saw this document because it was withdrawn for a while and updated in January, and I only saw it and read it properly in detail just before my trip to Rwanda, and I was really quite appalled. I was appalled that government ministers could continue to state that Rwanda is a safe country from a human rights perspective in the face of the evidence that they themselves had collated. And I really want to hear a bit of a colourable answer to that point. Now, on the issue of human rights, before the Joint Committee on Human Rights left the UK, we did take steps to find out about the human rights situation in Rwanda. And we heard some evidence about this. And what we heard gave me great cause for concern about the curtailment of freedom of expression in Rwanda for those who wish to criticise the government. And both the US State Department, Amnesty International and Human Rights Watch have reported evidence of unlawful or arbitrary killings, disappearance and torture. Now, one area of particular concern for asylum seekers sent from the UK is the protection of same-sex attracted and transgender people. Now, the Foreign Office travel advice for Rwanda warns British gay people and British trans people that, quotes, individuals can experience discrimination and abuse, including from local authorities. There are no specific anti-discrimination laws that protect LGBT individuals, close quotes. Now, when I put this to government officials and others with whom we met, I was reassured that the Rwandan constitution contains a general protection against discrimination, which in fact it does, but sexuality and gender identity are not listed there. But no one, crucially, nobody was ever able to show me any evidence that any gay or transgender person has ever availed themselves of the anti-discrimination protections in the Constitution. But people were at great pains to tell me, let me just develop this point, people were at great pains to tell me that homosexuality and transgenderism are not criminal offences in Rwanda. Well, I'm sorry to be light-hearted, whoop-de-doop. I can tell you as a lesbian that the mere fact that one is not criminalised is only the start of the story. I think Rwanda is where the UK, on LGBT rights, where the UK was about 50 years ago. Yes, it's ahead of many other African countries because it's not gay. It's not illegal to be gay or trans in Rwanda, but there are no positive rights. There are no equal rights protections. There are no positive rights. And I think we need to acknowledge that because there are people who come to these shores. They come to the United Kingdom because they're gay or transsexual, transgender, because they know that we have great world-class equal rights for gay and transgender people in the United Kingdom. I think if they're coming here for those protections, they're perfectly entitled to be concerned about being sent to a country like Rwanda where no such protections exist. Many other people come to this country because they were dissidents in their own country. They've criticised their own government. They come to the United Kingdom because at least so far here, touch wood, we've still got freedom of expression. I'm not sure that Rwanda can be described as having the same freedom of expression protections that we enjoy in the UK. I'll give way in a second. Asylum seekers also come to this country because they have been human rights defenders in their own country and they've been persecuted for being a human rights defender. Again, touch wood, in this country we still have full human rights protections. That, on the evidence of the Home Office themselves, is not the position on the ground in Rwanda, and I give way to the Honourable Lady.
You're making way for me again. You just say that the anti-discrimination law in the constitution in Rwanda isn't something that ethereally just hangs there. Isn't it in fact true that because of their recent history with the genocide, that it's a deeply ingrained feeling amongst Rwandans that everybody is equal and there is no discrimination? You're not even allowed by law to ask somebody if they are Tutsi or Hutu. They are very, very sensitive to anybody discriminating about anything. And isn't it also true that when we spoke to the heads of 2 NGO LGBT organisations, they were both very clear, and you had a very good dig into this. My honourable friend asked if it would be okay to hold hands walking down the street in Rwanda if you were gay, and the answer was yes, of course. You then asked if there might be...
Order. This is a speech, not an intervention. I'm terribly sorry. The Honourable Lady resume her seat. Joan Cherry.
My answer to that is, as I said at the outset of my speech, in assessing whether Rwanda is a safe country for asylum seekers, and in particular for LGBT asylum seekers, we need to look at what we heard from people when we were there, but also the objective evidence. The Honourable Lady will recall that I questioned several people about this. No one was able to give me any example of any gay or transgender person ever availing themselves of the law to protect their rights. The difference between that and the position in the United Kingdom, where anyone who is same-sex attracted or transgender is protected by the Equality Act, protected by the European Convention on Human Rights, if they lose their job, if they're refused housing, etc., etc., can go to court. So what I'm really saying is we need to look at what we heard there. Yes, we heard very positive things from 2 government-approved LGBT rights NGOs, but there is also evidence, particularly again in the Home Office note, she may scoff, but the note prepared by her own government, which suggests that the situation is rather different. So I'll give way.
I'm grateful to her for giving way, and she's making the case about the importance of evidence. And would she not also agree that there's actually evidence right in front of us by the fact that the UK government has itself accepted asylum claims from a number of people from Rwanda at the back end of last year? If it really was the paradise that we've just been hearing about, and if we could guarantee that into the future, then it would be quite surprising that people would be claiming asylum from that country to the UK.
Before the Honourable Lady resumes her speech, we are beginning to go very wide again. I'd be grateful if she could come back directly to the amendments. I understand the context in which she's trying to make her remarks, but I nevertheless think we're now beginning to go rather wide. And while I'm on my feet, got to just say that we're beginning to get onto fairly thin ice when we start talking about a JCHR committee report. I appreciate the Honourable Lady's being very careful, but it hasn't actually been reported yet. So we do need to be a little bit careful.
Clear at the start of my speech and in anything I've written about my trip to Rwanda that I have spoken in a personal capacity. The reports I referred to earlier were historic reports of the committee. I have gone out of my way to make it clear that I'm speaking in a personal capacity. I said that at the start of my speech. I explained in some detail that the committee will deliberate and report on its trip to Rwanda as part of a future report. These are my personal reflections, but they are evidence-based, and I stand by them, and I think they are an important contribution to this debate, and I do not intend to be shouted down by the honourable gentleman or anyone else who doesn't want to hear a lawyerly, evidence-based contribution. Well, I'm terribly sorry if I'm boring the honourable gentleman, but he'll be pleased to hear that I'm coming to the end of my speech very soon. To sum up, based on the evidence I have read and the evidence the Joint Committee on Human Rights has heard so far, based on what I heard and saw on the ground in Kigali, I remain of the view that Rwanda is still not a safe country for asylum seekers. That is why I'm supporting amendments number 2, 3, 4, 5 and 6. And I'm fortified in doing so by knowing that that is also the opinion of the House of Lords International Agreements Committee when it undertook its scrutiny of the treaty, and also the opinion of the United Nations the UNHCR on the ground, who told me, and I quote, "Systemic and structural change needs to happen in Rwanda, and then it needs to cascade." I believe that will take time, and I believe a greater commitment to meaningful human rights protections is also required. Thank you.
Order. When I said that we were skating on fairly thin ice, I did so because other equally impressive legal advice suggests that there are 3 members of the Joint Committee in the Chamber who have come fairly close to quoting from reports that haven't yet been published. I hope the Honourable Lady will accept the admonition in the terms in which it was offered. Caroline Lucas. I beg your pardon, Caroline Johnson.
Thank you, Mr Deputy Speaker. I rise to support the government this evening in rejecting the Lord's amendments. I want to focus my remarks most particularly on numbers 6 and 7. Number 6 says that the Secretary of State or the immigration officer could decide if Rwanda is a safe country for the person in question. And clearly this is a wrecking amendment, and I wonder if these immigration officers described would have been to Rwanda, as I have and as the Joint Committee on Human Rights have been last month. Because if they had, I think their position on Rwanda may change, because Rwanda, as I saw it during our visit to Kigali, it was a beautiful city. We met many very welcoming people. As the Honourable Lady opposite has said, Rwanda is a country in which many of the population are refugees, and as such they feel very keen to support people who are refugees and give them the best future. And we saw much provision that the government of Rwanda has made jointly with the government of the UK to support Rwandans on arrival, from purposes of housing and education, and the detail and level that they'd thought of for the things that people may need when they arrive in the country for the first time. We saw a country that's welcomed people from Burundi and the DRC, from transit camps in Libya, and reaccommodated an entire medical school from South Sudan, a girls' school from Afghanistan, and a large number of LGBT individuals from across the different African nations due to Rwanda's relative safety for such individuals. We saw a country scarred by genocide 30 years ago, who are keen and ambitious to work together for a cohesive and successful future. And when it comes to the visit and what we heard, I think, as in the words of our late Majesty, Her Majesty the Queen, recollections may vary, and I think it will be helpful, since we've heard contrasting opinions, just to give a little bit of information, but specifically in relation to LGBT, because Amendment 6, 1b, says that a court or tribunal would be able to say that Rwanda is not a safe country for a person in question, or for a group of persons to which that person belongs, group of people to which that person belongs. And I was very concerned to see what the LGBT rights were in Rwanda and whether or not it was indeed a safe country. What we learned while we were out there is that they do have a anti-discrimination law within their constitution, which can be litigated on if it needs to be. We heard that from the Supreme Court judge, the president of the Rwandan Bar Association, and the chief executive of the Legal Aid Forum in Rwanda. We visited Kepler Higher Education College, where we spoke to students and staff, including the chief executive, who's moved there to Rwanda from Canada, and a diversity officer for the institution. And we heard from all of those, the students, the staff, the diversity officer, the chief executive, that it was a safe place for LGBT individuals to live. They did say that there was some, what they called quiet disapproving amongst some of the older populations in Rwanda. And I note that while we've been talking on this debate, there has been a debate in Westminster Hall about LGBT content on the curriculum, which suggests the same may be true in this country, sadly. We also met with LGBT activist groups, and I wasn't aware until the Honourable Lady opposite said so, that these were government approved, or that any of the people we met were necessarily government approved in that respect. But they described themselves as LGBT activists. They're from 2 different organisations, and they, as others, told us that gay people can walk hand in hand with each other, and they're able to campaign openly without fear for what they are doing. The other issue I wanted to raise was 161C, which is the decision maker considering whether there's a real risk that Rwanda will remove or send a person to another state in contravention of its international obligations, the business of refoulement that was brought up by our Supreme Court. I think How can someone prove they will not do something until they have not done it? And that is quite difficult to prove. And I know that other honourable members have mentioned that somebody may have been subject to refoulement more than 11 years ago. And that may be true. The question is whether it will be true now. And what we see is a Rwanda who has the world watching, who has entered into a legally binding treaty, who's very ambitious for its future, who's genuinely, very genuinely caring as a population and a government of those who seek refuge. Why would they breach it? What damage would it do to the Rwandan government's reputation to breach such regulation by refoulement of people? It would do huge damage, and therefore I think we can trust, in having met with members of the government there and members of the public there, I think we can trust that they wouldn't. I will give way to Honourable Gentleman.
I'm extremely grateful to Honourable Gentleman. She, as I did, and like many other members of this House, sought to strengthen this bill, including Clause 4, knowing that people's individual circumstances, as they gain the asylum system, can be acquired, altered, or amended, and frequently are. But the Laws Amendment she refers to, Amendment 6, not only does not strengthen the bill, it weakens it. It makes Clause 4 even weaker. And the interim orders that would be issued as a result of that amendment would delay and obfuscate and make a nonsense of the intention of this bill. She knows that. She's articulated it very well, as she always does, and the Lords know it too. This is a wrecking amendment, nothing more and nothing less.
Thank you. I completely agree with my right honourable friend. It is, as he says, one of many wrecking amendments that the Lords have passed, and we understand that they, in the other place, wish to do so. But as a democratically elected chamber, we need to send it back to the Lords with a very clear message that this is what the people of the United Kingdom want to see. I wanted to clear up an issue relating to our meeting with the UNHCR based on my contemporaneous notes that I took in Rwanda and have with me today in the chamber. The UNHCR representative in Rwanda was asked why is there some apparent contradiction between their desire to bring refugees to Rwanda from other nations, but specifically not from the UK. What is it about a person having come from the UK that makes them less safe in Rwanda than a person who's come from Afghanistan directly, which doesn't seem to make sense to me. And they said very clearly that Rwanda is a welcoming country. The lady said this is nothing to do with the safety of Rwanda, quote unquote. She felt that the UK should keep its own asylum claimants and was concerned about Rwanda's capacity. She also said that she thought the UK had a more experienced system, and she felt that because most of the current refugees that Rwanda is accommodating, she said 95% are from Congo or Burundi, there was a similar culture, ethnic and religious population, and she thought it would have greater inclusion more quickly and integrate more quickly. I did ask her to expand on whether the UN would be more supportive of the scheme if all of the individuals relocated were of such origin, and she wasn't willing to answer that question. The other issue I wanted to just touch on was Clause 7. There's been much talk this afternoon of the safety of children in Rwanda, and one of the things the government clearly has to do is it has a duty to protect all children. And one of the challenges is that we know we do have people who will pretend to be a child when they're not, and one of my honourable friends gave an example of a gentleman who did that at the age of 42. The government has to protect children from being deported places they should not be deported to. It also has a duty to protect children in the United Kingdom from being accommodated or educated with people who are not children and who therefore may cause them harm in that place. And so the government has a duty, in my view, to make its best efforts. Now, these systems are not perfect, but they are the best that we have. And so it is right, in my view, that the government makes its best efforts to ensure that it does assess the age of children using the most important medical interventions that we have at the moment. So I'm pleased to say that I'll be supporting the government this evening.
Well, order. We're introducing an 8-minute limit straight away. I'm hoping to get the Minister on his feet to respond no later than 10 to 8. Clearly, if we finish before then the Minister may have more time. Claudia Webb.
Mr Deputy Speaker, this government remains in disarray for all the wrong reasons over this horrendous bill. I applaud the noble lords in the name of decency and humanity in bringing forward the amendments they have. The decision to force those seeking refuge here onto a cramped barge, the Bibi Stockholm docked at Portland Port, was rightly condemned by human rights groups as inhumane and dangerous, and has already seen at least one suicide. Yet this government wants to outdo itself in its contempt for human rights and life by sending vulnerable asylum seekers who have already been through a living and torturous nightmare to get here to a country our Supreme Court has ruled cannot be considered safe, and is now resisting amendments from the other place that are clearly designed to prevent injustice and to stop the government exploiting the Illegal Migration Act 2023 to truncate the process of forcing refugees to a country that does not become safe simply because it is called safe. That's how profound the Conservatives' contempt for justice and the rule of law is. The idea that Rwanda becomes safe simply by declaring it so is self-evidently nonsense. Nothing more than a manoeuvre to scrape for votes by pandering to racism. If the government declared tomorrow that Gaza is a safe destination, would that mean no more bombs, bullets or starvation there? Yet it seems the government thinks you can make juggling knives safe simply by declaring it safe. Presumably, any fingers chopped off would be someone else's fault, anyone else's, as long as our government gets their way. As the Lord's amendments make clear, the bill remains clearly at odds with human rights law and our commitments under international convention. And thus, the Lord's amendments are an attempt to mitigate some of the worst harms of a manoeuvre that shames our nation. One that in effect tries to opt the UK out of international human rights law by saying courts cannot take it into account, all whilst the Prime Minister tries to save face by saying the UK won't actually believe in those international agreements. Amnesty International has rightly condemned this assault on human rights as callous, immoral, and an attack on the basic protections that keep us all safe. It's also a hugely expensive one. This wicked scheme has already cost the UK 240 million in payments to Rwanda, with at least another 130 million to come. The bill fails to understand that there is no such thing as an illegal asylum seeker, and that safe and legal routes are needed to better protect all asylum seekers. This bill is ridiculous and toxic, racist and cruel, and it shows contempt for our legal system. Supposedly the government would have you believe that such attitudes reflect British values. But surely the people of this country stand for something better than stoking fear and hate towards desperate refugees alongside disdain for our legal system. I believe this whole bill should be rejected, but I support all of the amendments sent from the other place, as they go at least some way, Mr Deputy Speaker, to reducing its poison. Thank you.
Dame Priti Patel.
Thank you, Mr Deputy Speaker. Unlike all honourable and right honourable members who have sat through the debates, and actually these debates in recent years, there is a strong sense of déjà vu today, because in fact, I think it's almost 2 years ago to this date, we were considering Lord's amendments to the National Anti-Borders Bill, and actually some of those amendments fit with the debate today and the amendments that have come back from their lordships that are now being discussed. They touched on processing asylum claims of third parties, issues around safeguarding of children, and obviously safety when it comes to asylum seekers. But what this debate and these Lords' amendments really should be focusing on are the provisions in the bill, but also ensuring that the Migration and Economic Development Partnership, and that is what it's called, with Rwanda, can be operationalised and delivered as planned. Now, their lordships in the House of Lords have a vital role providing challenge and scrutiny. And I hope all honourable and honourable members have read the contributions from the debates. Lord Baker of Dorking gave some insightful comments, actually a man who understands some of these issues, having been Home Secretary during the 1990s, and his comments were insightful around dealing with migration and challenges, but also the wider issues around asylum seekers, criminality, and all those points that actually encapsulate the challenge that confronts the government. And today should be a balancing act while debating those amendments to recognise that there are political choices that have to be made. But also when we look at the international conventions and international agreements on human rights that have been touched on, some of them were designed in a totally different era. And I think we do have to recognise that. And I noticed the debates around UNHCR. I've had many of those direct conversations with the director of UNHCR, I should say, and they subscribe to the EU's position, which is actually one of burden sharing across countries around the world. That is not a position we subscribe to, and we should continue to uphold that and stand up for our own positions, because at the end of the day, the government, through what it has proposed, is effectively trying to put solutions forward. I do note that the Lord Bishop of Durham, for example, spoke in measured and thoughtful terms about the developments and the commitments given from Rwanda, but of course he did raise concerns over the opportunities that would exist for those transferred to Rwanda, and that is why we did negotiate this partnership. It's an economic migration partnership. It is an innovative approach. I was the first to say that when I launched this at the dispatch box. It's novel, it's innovative. But importantly, we put security and scrutiny measures in place. The monitoring committee, which I don't think has been given enough hearing today, also in the Lords' amendments, basically do what this House has asked for, and the Lords themselves, their lordships, will know this. So I am very concerned that some of the amendments that have been tabled will effectively, they're down to derail the bill as it stands, but actually a pragmatic, perhaps an innovative approach, I should stick with that phrase, an innovative approach to actually tackling some of these issues. I do want to touch on a few of these Lords' amendments. Many of them have been debated already, so I'm not going to cover them all. I think Amendment 1, as my honourable friend, the member for Stone, touched on, I am in complete agreement with him. But I do just want to flag that the Lords' Amendment 7, tabled by Baroness Lister, which has been subject to debate around children, I mean, we must recognise the fact that actually it was, Mr Deputy Speaker, the Nationality and Borders Act that put forward the amendments and the changes around safeguarding children in our own education system and in our local government system as well. That is vital. I think this is a moment now the Lords have tabled this amendment to reflect upon actually implementing these measures and these proposals. It's absolutely vital, it really is. And these were important provisions. I will give way.
So do you agree with me that these measures to assess children's ages are only really necessary because there are adults who will pretend to be children?
So my friend is absolutely right. And in fact, it was while I was Home Secretary, it was brought to me the case of a 42-year-old who was masquerading as a child, and in fact it became a national story. And it is through that, Mr Deputy Speaker, that we did look at the age assessment measures, and we worked with scientists, but also we looked at other EU countries and what they were doing. I would urge the government to get on and implement this. Time has lagged too long now. You know, it's almost 2 years. But these safeguards and protections are absolutely critical. They really are. I think it's important to remind the House and those tempted to back the Lords' amendments the reasons why we have this bill and the partnership. And again, it is because of the global challenges that we face on migration. And, you know, this isn't about a disregard for human life. That's what the people traffickers are ultimately doing. And that is what we are having to tackle. Lives lost at sea in the Channel. Horrific and brutal acts. And I've heard about them and I've seen them, and I know sadly too much about criminal gangs benefiting and profiteering from these, quite frankly, barbaric acts. But there are some areas that I would just like to touch on before I close. And the partnership itself is evolving. It is starting to look somewhat different, Mr. Deputy Speaker, from the original partnership, the Economic and Migration Partnership. And that actually links to the concept that has been raised actually by the Shadow Front Bench about the voluntary removals. And I think we touched on this last Thursday in the estimates debate as well. I think in light of the recent announcement, I'm sure the Minister will address this, but I'm sure their Lordships and all honourable members will want to press on this as well. There are benefits to voluntary returns. That principle has been in place for a number of years and it does work and we should encourage it. But there is the whole issue about re-entry bans, which again, Section 40 of the National Anti-Borders Act amended Section 24 of the Immigration Act 1971 to actually deal with re-entries that do take place. We have to be honest about this. They do take place, even though voluntary removals happen. And it is important now that whatever happens with regards to the operationalisation of this bill, that these areas and loopholes are effectively shut down. Because the whole point about voluntary removals, it's a strong scheme, but we must make it work. And my final point really is that with regards to these amendments, there are so many aspects. Even Lord Brown's amendment, if I may say so, it is tragic, I have to say, that we are debating, you know, Afghans who, quite frankly, should have been resettled in the right way in our country for various reasons. And I have to say, it does pain me, and it did pain me to listen to the debates from their lordships on this. We have a proud record in this area. Also, we've all, in our own constituencies, we've been host to so many people from Afghanistan. I remember Operation Pitting as if it was yesterday. It was a moment of crisis, and we had Border Force staff who were put into Afghanistan, into Kabul, to do the right thing, actually, to do the airlifts and to work with the MOD. And I have to say, it was a harrowing time, but the ARAP scheme and the ACO scheme, everything that followed since, was done in good faith. And I think we must uphold those principles. To conclude, Mr. Deputy Speaker, this is a pivotal moment when it comes to Rwanda and the safety of Rwanda bill, but actually the overall approach that this government takes. Whatever way, and I will be voting against the Lord's amendments, but whatever way the House chooses to settle on the direction of this overall policy, we are sending out a very strong message to the British people who themselves are exasperated because they do see a government that feels that its hands are constantly tied. There's a carousel now, a revolving door of setback after setback, and we have to now give the government, I think, not just the benefit of the doubt, but actually the tools and the ability to get on and operationalise this policy. And I think we're at that pivotal stage right now. I will give way to my honourable friend.
I'm grateful for the right honourable lady. She's mentioned the Afghan scheme. I understand the debate that's gone on about the safety of Rwanda. Yes. My concern is this, and I've dealt with Afghani refugees, as the honourable lady knows. Many of them are on the edge of real mental health issues as a result of the traumas they've experienced. I actually think the experience of them coming here and then being put at risk of being effectively deported again to another state will push many of them over the edge. That must be a factor that gets taken into account, and that's why the amendment from the Lords is so significant.
Understand the honourable gentleman's position, the right honourable gentleman's position on this fully, but I do think this is actually a moment of reflection for the government as well, particularly with those that have served our country and worked alongside us in Afghanistan. And I do think that is a point of clarification for the government itself in terms of how it has been and continues to aid people who, quite frankly, we know are on the border of Pakistan. And Pakistan itself has a range of problems in its own country right now around migration and governance issues. But to conclude, Mr. Deputy Speaker, we are at a pivotal moment with this piece of legislation. We are also at a crucial moment, if I may say so, with our relationship with the government of Rwanda, who have been a solid partner, a respected partner as well, diligently working with us. Obviously, I speak with full experience as the original architect of the Migration and Economic Development Partnership. I do think we have to go back to the basics of that partnership. I do feel, I said this last week in this House, this has moved beyond some of the core principles of the original partnership. I would urge the government to very much do what it needs to do in this House today, settle some of these issues, but really just knuckle down now and work on the operational delivery of this scheme.
Alistair Carmichael.
Thank you very much, Mr Deputy Speaker. It's a pleasure to follow the Right Honourable Lady, and in particular the context that she gave to this debate, which I think is important and is worth reflecting on for a second or two. She reminds us, of course, that this is in fact the third bill that we have had in this Parliament, and indeed, as the honourable gentleman from the opposition front bench pointed out towards the end of his remarks, we now have another innovation in that people are to be offered a cash payment to take the opportunity of going to Rwanda. What does 3 bills and still an evolving political situation and a portfolio of arrangements tell us? I think it tells us that, in fact, this is a government that has no strategic purpose in the way that it is tackling this problem. And that has become apparent from a number of the interventions this evening and this afternoon. We've spoken an awful lot about the rule of law here and there. To be honest, this bill is not, and this debate is not about the rule of law. It's an entirely political exercise. I'm pretty certain that the government will win the votes tonight. I'm pretty certain that they will face down their lordships and that they will get their way. I'd be astonished if any of it actually makes any significant difference at the end of the day, because this is not about law. It's not even about really a meaningful approach to the problem of votes in the Channel. It's all about politics in the run-up to the election. One of the most telling interventions came from the Right Honourable gentleman from Kenilworth and Southam. His point about permanence was one which I thought was absolutely on point, and it's not without its significance that nobody has chosen to pick it up, because I don't think there really is an answer, or at least no good answer, to the point that the Right Honourable and learned gentleman made. I think on the question of permanence, let's just not ignore the context of where Rwanda is and where Rwanda has been politically and in relation to its neighbours. Just in January, the US State Department was saying to Rwanda and to the Democratic Republic of Congo that they had to walk back from the brink in terms of the conflict between them. Now, if they choose either or both of them not to walk back from the brink, then where is that going to leave the safety and stability of Rwanda as a destination for us to be sending people to? But the determination, as the Shadow Minister said, to legislate to say that somehow or another the sky could be green and the grass could be blue, it takes no account of these very real challenges that are somewhere coming down the track. I think I would just say this to the government. Look at the authors of the amendments that they're going to knock back today. Lord Hope of Craighead. I remember when Lord Hope of Craighead was first appointed as Lord President in Scotland, and then I have watched his progression through to being head of the Supreme Court. This is not a man who is given to making grand political gestures. This is no wide-eyed radical. And when he comes up with an amendment to say that the purposes of the bill should be done in accordance with domestic and international law, then I think that makes perfect sense. It's not to be forgotten that the roots of this legislation are to be found in a judgment of the Supreme Court. That was something which caused an enormous frustration in government circles. We don't forget that. But, you know, obeying the law is not an optional extra for any government. But even if what we are trying to do here is to circumvent the effect of, or the scrutiny of the courts, then to resist an amendment that says that, in fact, where evidence is presented to the contrary, through their own decision makers to rely on, simply defies any sense of logic. The Honourable and Learned Lady from Edinburgh South West earlier in her contribution made extensive reference to the Home Office guidance in relation to human rights in Rwanda, and her point was a very good one. But it is a nonsense, surely, that in one office, in the Home Office, there are people beavering away, working out the human rights position in Rwanda, while in another office in the same building, there are people drafting clauses saying that the people who will then make the decisions should not be allowed to have any account of it. It makes no sense. If we were to be serious about finding a solution to the problem, to breaking the business model of the people traffickers, then the government would be taking the opposition, the Scottish Nationalists, ourselves, all parties in, and trying to find a common way forward. In fact, they're doing the opposite. They are seeking to manage the issue politically in such a way as to increase division and not to build consensus. So yes, they will be able to, in the time that it remains to them in government, to win votes like this. But they won't do anything to stop the traffic. And ultimately, they will have to be replaced by those who will.
Sir Michael Ellis.
Thank you very much, Mr Deputy Speaker. And I rise to reject and oppose all 10 of the Lord's amendments. And in the other place last week, peer after peer spoke of this bill as an outrageous affront to the law or quote-unquote international law. And with great respect, there seemed to be a collective amnesia that it is Parliament that is sovereign, and that Parliament secured sovereign authority over generations from what had previously been, of course, an absolute monarchy, probably stemming from the Glorious Revolution of 1688. Parliament for centuries now has had sovereign authority to pass any law whatsoever. No law that Parliament passes can be, quote-unquote, outside the law. In our system, it is Parliament which is supreme. Despite the misnomer of the court that Tony Blair invented, it is Parliament that is supreme, not lawyers or judges. This is very unlike the United States, for example, where the judges are able to strike down a law passed by Congress as unconstitutional. In fact, the UK legislature could actually do the opposite of that and strike the Supreme Court down out of existence if such were Parliament's will. That is, after all, what Tony Blair himself did when he abolished the 150-year-old principle of the Law Lords and the House of Lords as our highest court, and created the Supreme Court just a few years ago. And many think that was an act of constitutional vandalism. But whether one does, and I happen to agree, but whether one does or not, it's axiomatic that what Blair did, one of his successors can, at least in theory, undo. That's the nature of our system. Parliament derives its authority from the people. And that is why parliamentary sovereignty is so important. It isn't an aggrandisement. It's because, as the member for Stone was saying earlier, it derives its authority from the people. And the law is a living and fluid concept. And people change and people's views change, which is why it is right that the people's elected representatives in Parliament can have sovereignty over decisions that are made. To give an example, 200 years ago, drawing graffiti on Westminster Bridge was an offence punishable by death. Now, one can block ambulances on Westminster Bridge and not even receive more than a small fine. The law has changed in 200 years, and it is imperative that we bear in mind that the law is a fluid concept. It has to keep up with the wishes and will of the people. And the point is that society changes and the law changes with it, and that is a major advantage of the English common law system. Today, Mr. Deputy Speaker, the British people have elected leaders, and my right honourable friend, the Prime Minister of this country, who advocate a policy of increased vigilance on immigration. And the elected politicians must be able to enact laws in accordance with the wishes of the people. And even if lawyers and members of the other place do not like that, that is the very essence of democracy. The law is not, and I've worked in the law my whole life. I was 30 years now since I was called to the bar. The law is not the master of the people. It is a servant of the people, as this House is. It must serve the wishes of the British electorate, and if necessary, adapt accordingly. The British people's current wishes on immigration are clear, and the Prime Minister is right to enact them. And this is not just a constitutional position. Mr. Deputy Speaker, 9 people have died trying to cross the English Channel in small boats this year alone. The latest victim of the smuggling gangs was a 7-year-old girl whose overloaded boat capsized in a French canal. So for this reason, stopping the boats is not just a political imperative, it is a moral necessity. And only when those coming to the UK illegally know they cannot stay will they stop risking their lives and the lives of others. Now, yet to, I'm sorry to say, Labour and crossbench peers in the other place last week, it's some sort of outrage to try to stop this trade in human misery by establishing what would be an effective deterrent through the Rwanda partnership. Now, in reality, despite the contributions of some members in the other place who were opposing this process, if one actually reads the Supreme Court's judgment last year, this bill, today's bill, is the constitutionally appropriate response to that judgment. The judgment related to the conditions in Rwanda at the time of the original challenge in June of 2022. And Lord Reid, the senior judge on the Supreme Court, was explicit that the issues identified could be addressed in future. In other words, the Supreme Court explicitly invited ministers of the Crown to remedy the problems that they had identified in their judgment. And that is precisely what His Majesty's government has now done, with a treaty that is binding under international law frameworks that Labour and crossbench peers so admire. So, nor does the Rwanda bill oust the jurisdiction of the courts. That's also a misapprehension. Judges will be able to consider human rights claims and judicial reviews. They will just do so after people have been sent to Rwanda, unless, of course, claimants can prove they will face a real risk of serious harm in Rwanda, in which case they can stay in the UK while the appeal is heard. And this is entirely...
You could mention the amendments now and again, that would be really useful.
Yes, well, thank you very much, Mr. Deputy Speaker. It is entirely reasonable. As I said at the beginning, these amendments are relevant to this whole concept. If one comes to this country illegally, one should not have the ability to repeatedly prevent one's removal at vast expense to the taxpayer. Yet because of Labour votes that were whipped, no doubt, by the Leader of the Opposition, the House of Lords defeated the government 10 times on amendments seeking to neuter the bill and ensure that no one is ever sent to Rwanda. They did not vote down the bill. They did not vote for these 10 amendments because they want it to work. They did so because they don't want it to work. And what none of those peers on the opposition benches did was provide an actual alternative to the Rwanda partnership. None of them could say how they will deter people from getting into overloaded dinghies on the beaches of northern France or prevent the deaths that will surely follow. So in voting against the bill, the Lords were therefore constitutionally, legally and morally wrong, and I urge the House to overturn their amendments today.
Caroline Lucas.
Thank you very much, Mr Deputy Speaker. Sorry, I almost fell over by surprise. I'm very grateful for the opportunity to take part in this debate. Mr Deputy Speaker, this bill is an affront to the principle that human rights are universal and that they belong to all of us by virtue of our humanity. The amendments from the other place before us today are an attempt to stop the government violating that principle and undermining not just Parliament, but I would argue the courts and the rule of law in the process. Despite unacceptable and unparliamentary pressure from the Prime Minister, who urged peers to rush their scrutiny and simply go along with his dangerous authoritarian bill, peers have rightly inflicted 10 defeats on the government. And they've done so by large majorities, signalling profound opposition to the Prime Minister's deeply illiberal, deeply inhumane Rwanda legislation. Mr Deputy Speaker, the Home Secretary's motions to disagree are consistent with this government's track record, frankly, of cruelty towards people seeking asylum. And we just had another example of that just very recently, the Home Office's recent jaw-dropping admission that they don't routinely inform family members when asylum seekers die in Home Office care. To begin with Lord's Amendment 1 in the name of the Noble Lord Coker, this amendment simply adds maintaining full compliance with domestic and international law to the purpose of the bill. One might have imagined that this would not have been up for debate. It is a measure of how low this government has sunk that they are opposing an amendment that simply says that their bill should comply with the rule of law. That is something I had thought members on the government benches were meant to believe in. In particular, Lord's Amendment 1 is needed to stop the disapplication of the landmark Human Rights Act, something I believe we should be proudly defending. It is also needed to protect interim measures, a vital human rights tool under international law, issued on an exceptional basis in extreme circumstances when individuals face a real risk of serious and irreversible harm. The bill states that, and I quote, the Parliament of the UK is sovereign and that the validity of an act is unaffected by international law. We've heard a lot more of that from the opposite benches just this afternoon. But I do think that ministers should stop misusing, in my view, the concept of parliamentary sovereignty, which is not about which is not embodied by riding roughshod over the courts. And I would draw their attention to a point made very clearly by Professor Mark Elliott, Chair of the Faculty of Law at the University of Cambridge, because as he explains, and I quote, Parliament can be meaningfully sovereign only within a functional, legal and constitutional system. And such a system can only exist if its other component elements are permitted to play their proper part. I would suggest that that is exactly the principle which the government is seeking to trample over with this bill. That brings me on to the way the government is attacking parliamentary sovereignty by undermining the jurisdiction of the courts. Lord's Amendment 6, in the name of the Noble Baroness Chakrabarti, is vital. It would allow our courts to play their proper part, to hear evidence, to scrutinise the legality of government decisions, to allow our system to protect individuals from risk of life or inhuman or degrading treatment. Likewise, Lord's Amendments 4 and 5 to Clause 2 at least allow for the presumption in the bill that Rwanda is safe to be rebutted. Without these amendments, the bill directs courts to ignore the facts that are in front of them. These amendments are a modest reprieve for facts and evidence in what remains a thoroughly vile bill. And it does seem quite extraordinary, again, that the government can be so fearful of evidence. Why would they not want to look at evidence in front of them? And could I perhaps refer them to the recently published World Report 2024, Human Rights Trends in Rwanda, because it makes pretty grim reading, and I quote, commentators, journalists, opposition activists and others speaking out on current affairs and criticising public policies in Rwanda continue to face abusive prosecutions, enforced disappearance, and have at times died under unexplained circumstances. So I also urge members to consider how constitutionally and legally astonishing, frankly, this bill is. The Joint Committee on Human Rights has been explicit about how extraordinary the legislation is, stating, and I quote, requiring the courts to conclude that Rwanda is safe, even though the evidence has been assessed by the UK's highest court to establish that it is not, is a remarkable thing for a piece of legislation to do. And that brings me to Lord's Amendments 2 and 3 in the name of the Noble Lord Hope of Craighead, former Deputy President of the Supreme Court. And there's been much discussion about these amendments, but they require monitoring of the safety of Rwanda, whilst accepting the assertion that the treaty makes Rwanda safe. So let us suppose for the moment that we suspend our disbelief, if we suspend our notice of all the evidence right now that suggests that Rwanda is not safe. Even if it were, how on earth can we be legislating that it will be into the future for any degree of indefinite time? That just seems, there is so much, frankly, in this bill that is just an affront to common sense, but that one seems to be in a league of its own. Facts change, and when they do, we need to change our view of those facts, and to do anything more, or rather to do anything less, seems to me to be moving towards a moment of madness. I want to be clear that whilst I will vote to uphold these amendments because they are an improvement on this dreadful bill, I maintain my view that seeking to legislate by assertion that Rwanda is safe is as dangerous as it is ridiculous. The government cannot sign a quick treaty one week and legislate the next to make a country safe when the highest court in the land has just said the opposite. The facts on the ground are what matter, and these amendments say the facts should be monitored. What kind of government, frankly, would oppose that? To conclude, I will vote to uphold Lord's Amendments 1 to 10 because they make the Safety of Rwanda Bill slightly less constitutionally transgressive and inhumane. The Home Secretary's motions to disagree with the Lords are, frankly, laughable, coming just days after he has been exploiting the desperation of vulnerable people by offering them £3,000 to go to Rwanda voluntarily. Amended or not, the bill remains a grotesque waste of money that is neither practical nor strategic. It is no less than a piece of performative cruelty from a dying administration. I will.
Thank you very much. Oh, John
decisions of the court itself. But we also, with regard to Amendment 9, we seem to be reversing the work that this House has put in to ensure protection of those who are victims of modern slavery and trafficking. And what this does is make them vulnerable again, particularly to the worry that we have about re-trafficking. So again, for the life of me, I cannot understand why there isn't support from the government for Amendment 9, because all it's doing is asserting in for the decision maker their opportunity to assess the impact on the health, mental health of and the potential of re-trafficking on the individuals concerned.
I thank the Right Honourable Member for his intervention, and he is absolutely right in what he says, and it just seems quite ironic that by refusing these amendments, in a sense, the government's going back on pledges and commitments that it has already made in terms of trying to uphold the issues around human trafficking. So on so many levels, this bill is so hugely damaging. And I did just want to say that others have spoken about essential amendments to provide at least some possible protection for unaccompanied children or for victims of modern slavery and those at highest risk of harm if removed to Rwanda. And frankly, voting against those, just as voting against Amendment 10 about the people in Afghanistan who have done so much for us and who have put their own lives at risk for our government and our country, the idea that we would just simply send them off to Rwanda. The Right Honourable Gentleman himself made a powerful intervention on this case about what that would do for people who are already in such a case of vulnerability. But I wanted to sum up, Mr Deputy Speaker, really with a kind of a message that I hope the peers in the other place will consider, because it is, of course, right and fundamental that the House of Lords should act in accordance with its subordinate position in relation to this elected House of Commons. That is the usual way that we proceed. The bar for the other place to override the Commons must be an extraordinary and profound attack on the very fabric and operation of our constitutional democracy. And I regret to conclude that it is precisely because this bill is that extraordinary and profound attack on the very fabric and operation of our constitutional democracy that the other place would be well within its rights. Indeed, it is its responsibility to uphold those amendments that it has already put, because this bill is demeaning and does degrade both houses by ignoring the rules of law that we have passed. Furthermore, this bill seeks to legislate facts. It seeks to prevent courts from considering them. Fixing the facts on which the law is to be applied is the kind of thinking that dangerous conspiracies are based on. That way lies authoritarianism, and so I do urge the Lords in the other place to put a stop to this bill, and I urge everyone in this House to vote in favour of the amendments tonight.
Sir Robert Buckland.
Thank you, Mr Deputy Speaker. And I note your strong exhortation to address the amendments, which I will do so in turn. Very briefly, it is tempting to get into a debate about whether this bill offends the rule of law. Rule of law is used as an absolute term. It is in fact a political term that is an important principle that underlines much of our constitution, but which sometimes is frankly misused and elevated in a way that I don't think does it or the debate justice. And indeed, it's been inevitable that we've had wider debates about the safety of Rwanda as a country, and the geopolitics has been discussed by honourable and right honourable members, but I think that misses the point. The point that we are dealing with is whether or not we can be satisfied that Rwanda, the Rwandan government, is indeed carrying out the obligations that it has agreed to in the treaty of late 2022. That treaty which has been underpinned by a government command paper, which is the basis, frankly, for the government to in effect answer the exam question put to it by their lordships in the Supreme Court. Now, in the other place, the noble Lord Howard of Limpley spoke very powerfully about the need for each arm of the Constitution to respect each other. I entirely agree with him. I've said that here in this context in previous debates on this very issue. Where I think, however, we are is perhaps not a place that constitutionalists like me want to be, but nonetheless we have a judgment of the Supreme Court based upon the merits of the case, based upon the test that it is allowed to apply, namely whether there was a risk of either a breach of the European Convention on Human Rights, or actually in this case more risk of refoulement under the Refugee Convention. And then to answer that question, they decided there was a risk, and therefore the government has rightly tried to take action to fill that gap. And I would simply ask my right honourable friend and learned friend this: is he satisfied that the helpful steps outlined by their lordships International Agreements Committee in their report of the 17th of January of this year are being undertaken? Those 9 points that ministers in the other place were pressed on repeatedly by, amongst others, the noble Lord Carlisle of Beru, who I think made the point very powerfully. I'm not going to recite the 9 steps, but they relate to making sure that the process by which Rwanda deals with claims is fair, is transparent, and is in accordance with the obligations that they entered into in the treaty. It is important, I think, that the government and my right honourable friend address that point, because I have to say, Mr. Speaker, that whilst I think that Amendment 1 is just adds more legal potential justiciability and legal argument to a clause that I think I've said on other occasions I despise, because it is full of declaratory law at best, and frankly creates a lot of legal opportunities for my colleagues in the profession, and I declare an interest, of course. I don't think you can perfect that by adding that particular amendment. However, amendments 2 and 3 do seem to me to have force. Because I think it is vital that if we are to go down this road of using deeming provisions, that we do not end up in a position where the law has gone so far ahead of the reality, namely Rwanda's either failure to or slowness in carrying out its treaty obligations, that we end up creating that legal fiction that I think a lot of us are rightly worried about. And therefore I'm minded to support those 2 amendments. I think that the amendments that were amendments 4 and 5 relating to I'll give way to my honourable friend.
I'm extremely grateful to my right honourable learned friend for giving way. I wonder, before he moves off amendments 2 and 3, as he knows, I share his concern about the artificial finality that the current drafting of the bill presents in relation to amendments 2 and 3. But would he agree with me that the problem with amendments 2 and 3 is that as they are drafted, they give all the authority to the monitoring committee related to the treaty, because it allows the monitoring committee, by a process, to determine that there's not been adequate compliance with the treaty, and that then feeds through automatically in the wording of the amendments to say that it is no longer a safe country. And that is a decision which, on the rubric of the rest of the bill, should remain with the House of Commons and the House of Lords, and not with the monitoring committee.
I think my right honourable friend makes a very powerful point. I think this amendment is capable of perfection. I think the suggestion I made at report stage was for the bill not to come into force until a Minister of the Crown was satisfied that Rwanda had satisfied its treaty obligations, both internationally and domestically. fundamentally, and I take his point. I think there is more that can be done, but I do think that there is force in their lordships pursuing that particular point, so that we marry up the reality with what we want to achieve legally. I have to say that I think unless that is done, then my position on Amendments 4 and 5 is that I'm minded to support them, because I'm yet to be satisfied that we're in a position where a deeming clause, which although is not unprecedented, and of course has been used, of course, on a number of occasions, and there's nothing unconstitutional about that, it is actually reflective of the reality. I think the amendments relating to Clause 4 just complicate the position. Clause 4 is a very clearly drafted clause to deal with particular individual cases, and I don't think we should be upsetting that. And I think that similarly, with regard to some of the later amendments, I think 7 and 8 really don't take matters, I think, significantly further. 9 and 10, however, I think do have some force. I think that exemptions relating to modern slavery should be clear. We have led the world in our modern slavery legislation, have a proud record, led by, amongst others, the Right Honourable, my Right Honourable friend from Maidenhead, and others in their Lordship's House. And I think it would be unfortunate, to say the least, that we end up with this bill, I'm sure unintentionally by my colleagues, my friends on the front bench, riding something of a coach and horses through those important provisions. And I'd say finally, on the Afghan provision, my right honourable friend Whittam, she and I were both in the trenches on that back in that summer of 2021. We both lived through that time. I was helping to get judges out of Afghanistan. My honourable friend was working day and night to make sure that we save people who had risked their lives for our way of life. And I absolutely take her point. In fact, I would go further and say that I think the government should, although I would expect the government to be very sensible and sensitive to the position of Afghan refugees, any future refugees, and not put them into this scheme. It does seem to me to lose nothing by adding this particular insertion. So for those reasons, these amendments are frankly a curate's egg, as all Lord's amendments are going to be. But there are times, Mr Deputy Speaker, where I do think it is important that a point is made. And I'm afraid this is one of those occasions where I'm going to make that point. Thank you.
Thank you very much. Sammy Wilson.
Thank you, Mr Deputy Speaker. Can I first of all say that my party supports this bill and wishes that it does come to successful fruition and achieve the objectives that it seeks to achieve. And I'm not going to rehearse all the reasons that have been rehearsed plenty of times in other debates, but we have to tackle the criminal gangs. We cannot go on with the pressures which illegal immigration, mass illegal immigration, puts on society, and the costs which it puts on society and on the government and on the taxpayer. And for that reason, we will oppose most of the Lord's amendments, which, as the Minister has rightly pointed out and other speakers have pointed out during this debate, many of them are designed to weaken this bill, to undermine it, and to ensure that it doesn't work and that we just remain with the old, flawed system that we have been trying to put aside. The Minister has said that the reason why the government opposes him, he's right, that he doesn't want to see the bill weakened. But could I say, Mr Deputy Speaker, the bill is already weakened. It's weakened in respect of one part of the United Kingdom. And I would seek assurances from the Minister as to how he comes to the conclusion that he believes that by pushing the bill through in its present form, it is going to safeguard all parts of the United Kingdom against illegal immigration being channeled through different parts. Because the government has made a promise, first of all, in the Safeguarding the Union document, that this bill will apply to the whole of the United Kingdom. Although that was written with the full knowledge of a court judgment in Northern Ireland, that the provisions of this bill could not apply to Northern Ireland because of Section 7 of the European Withdrawal Act and Article 2 of the Windsor Framework. And there have been two more court judgments since then that make it quite clear that because of Article 2 of the framework, then this can't apply to Northern Ireland. And the full weight of EU law, the full protections of the European Convention on Human Rights and the European Charter of Fundamental Rights applies. And that means that many parts of this bill will disapply in Northern Ireland. Now, there are 3 court rulings on this. The government knows what's in the Windsor framework and knows what's in the withdrawal agreement and the Withdrawal Act, and yet still continues with this argument that despite all of that, this still applies to Northern Ireland. And I would like to hear from the Minister where that assurance comes from, given that he knows the terms of the legislation, he knows the terms of the Windsor framework, and he knows the judgments of the courts on 3 times in October and February, and then at the end of February again. The implications, of course, are that if Northern Ireland becomes the weak spot in all of this, then this becomes a meaningless. And I mean, people think, oh well, Northern Ireland, the boats aren't going to come from France up across the sea into Southern Ireland, and sort of a 24-hour journey, and then people come up through. But it should be remembered, Belfast already, out of 77 cities in the United Kingdom, has the 2nd highest number of illegal immigrants per 10,000 of the population. So already it is a channel through the Republic into Northern Ireland, and then of course into England. So this is an issue which needs to be addressed. First of all, because a promise has been made in a government deal, and secondly, because of the way in which this could undermine the whole immigration policy. Or of course the real difficulty is, and the real danger is, that if Northern Ireland does become that channel, then we'll finish up not just with a border for goods, but we'll finish up with passport controls for people moving from Northern Ireland. So, I mean, I
mentioned some of the amendments as well.
I am, Mr. Deputy Speaker, and the point I was making was that the government, and we will support the government in rejecting amendments 1 to 6 because it weakens the bill. But the government also has to recognise that its own inaction is weakening the bill as well. When it comes to, I'm surprised at the attitude which the government has adopted Amendment 8. I would have thought that since this policy is designed to assure people that the government has now got on top of illegal immigration, I'd have thought that they would have welcomed the opportunity to publish on a daily basis the number of people who have been removed from the United Kingdom. In fact, I would have thought that it might have done a Ken Livingstone and put a banner on the building across the river and on a daily basis published, this is how many people we have removed. Or is it really that the government knows that this bill is not going to have the effect, and that the publication of such information would be an embarrassment? The other amendment, we'll be supporting Amendment 8 because we believe that there should be a very public way of judging the success of this policy. The other one, and I really can't understand the government's attitude to this one either, I believe we have a duty to those who served with the army in Afghanistan at difficult times, put their lives at danger, and are now in danger of losing their lives under the brutal Taliban regime, which now wants to take revenge. It's not that people can, the people could sneak their way into the United Kingdom because we have good records of those who served and served the army. They're at risk. Their families are at risk. And surely we have a duty. I can remember speaking to some people from Northern Ireland who had served in Afghanistan, who spoke glowingly of the ones who, the folks who interpreted for them, the folks who gave them the background knowledge, who went out with them on patrol on a daily basis, who supplied them with information, etc. We have a duty to those people. And I can't really understand why the government would resist Amendment 10. We'll certainly be supporting that amendment as well, because we believe that we have an obligation. But I would like to hear from the Minister today how the promise which is made in paragraph 46 of the Safeguarding the Union deal is going to be delivered in Northern Ireland, given the facts that we know already, where courts have judged and ruled that this bill cannot apply in Northern Ireland, and if it can't apply in Northern Ireland, is the government aware of the consequences for Northern Ireland being further isolated from the rest of the United Kingdom?
Gavin Foster.
Thank you, Mr Deputy Speaker. It's always a pleasure to follow the member for East Antrim. I agree with much of what he said. On one or two of the amendments he plans to support, I will be differing from him on those. Mr Deputy Speaker, it's worth remembering what the purpose of this bill is. It's about dealing with one of the knottiest problems in illegal migration policy, which is what you do about those who leave a safe and democratic country to come to the United Kingdom as a choice, and then when you cannot, return them to their home country, either through the domestic policy of that country, as the Minister will know, or through a country where realistically we are not going to be able to engage about immigration removals. And then they seek to take advantage of our asylum system. And in many cases, this is the absolute core of the people traffickers' business model. And this can actually, by the way, include people who've actually had lawful residence in another safe and democratic country, who then come to this country and apply for a refugee status. So this is what, for me, the bill has to be about. It's actually delivering a process that breaks the people smugglers' business model. And that's why coming to these Lords Amendments, I think it was, please see him in his place, the Honourable Member for Kenilworth and Southern, really summed it up, that these amendments are not about making this bill work better. It's not about getting this process in a better place. This is all about actually creating routes to challenge, creating routes to delay, creating routes to block up. And here's some of the points made about, as he says, about the permanence. And of course, Parliament's always free to take a different view on legislation presented. No Parliament can bind another constitutionally, so clearly a future Parliament could take a view. It is no longer safe, but for now we are quite entitled to take a view as to whether it is today. And I think particularly with the treaty obligations, particularly with the work being done, we can say that Rwanda is safe for a refugee to be transferred to. And that is what the core of this bill is about. It's about actually working with another country that is an expert in resettlement, about being able to provide, if there is a genuine safety need or seeks for safety, that we can work with them, but not allowing continuing the idea that if you pay a trafficker, you can choose where that safety need is met, i.e. here in the United Kingdom. And I would say that's why, for example, seeing things like Lord's Amendment number 6, which allows a range of challenges to go up to the idea that Rwanda isn't safe. Well, again, I look at the fact that Rwanda is a place working with the UNHCR on refugee resettlement. If it was inherently dangerous to take someone to Rwanda, if there was a massive danger of refoulement on to a country where they would face persecution, then that is a system that could not exist. So for me, it is perfectly reasonable to say we can come with our own agreement with Rwanda. That would be effective, that would be respected, and then rely on that in defining the country as safe. Now, some of the other elements around things that we've touched on already in the debate, and I sadly don't have time to go into all the issues around some of the issues we had with our age assessment system. But again, similarly, it is perfectly reasonable to say that as with the new processes coming in, we can take a view. And again, a lot of challenges are raised up, not because they are something that will ultimately succeed, but because it delays removal. Now, I am going to disagree a little bit with what the member said, and some of us have said, around Amendment number 8. First, the fact it says referring to all individuals, in a strict interpretation, that we'd be listing everyone's name and address, which would clearly not be appropriate at all. Neither, by the way, would it be appropriate to list the timetable for the removal of individuals from this country. That would involve going into a publication of data that the government would not normally go into for, I think, fairly obvious reasons. But I do think, the idea that we're not going to get reports and constant commentary on how this is going without putting an amendment into this bill is, I don't think, stands up. And also, having worked again, like the Honourable Member for Witham, on op pitting, I saw the work we did to get people out of Afghanistan. And yes, we do need to look at how we can unblock some of the ARIC process. But I have to say, a lot of that's actually to do with finding places to settle here in the UK. That is one of the biggest issues with many of our resettlement schemes. One of the great successes of the Ukrainian one was actually people coming forward. But with the Afghan one, we were reliant on, in many cases, local councils to offer spaces which, unsurprisingly, given some well-known housing pressures, not many rushed up do. So I think there's a debate there to be had. That is not resolved by amending this bill and providing another route to challenge or make a claim, which with a likelihood that that route will be used by those who perhaps never did anything to do with our forces, but see it as a way to stop being transferred to Rwanda. And I do find it interesting, some of the counterintuitive arguments we've had as well from opposite, that this is all a bit of a gimmick, that this isn't going to work. Well, if that was the case, why waste time amending the bill? Why not let it go through, let the government get its legislation, and then spend the rest of the year saying, look, it didn't work. Instead, we know what the real fear is that if this bill goes through, this plan will work. And it is something that I think can be perfectly credible and go forward. And some of the objections we've heard just sit with me against the fact the UNHCR is taking people to Rwanda itself in very large numbers, as has been quoted already during this debate. And without this bill, and without it being an effective bill, i.e. not having these amendments added to it, what is the other plan? What is on offer to try and break that fundamental part of the people smugglers business model? When we're told about cracking down on gangs, one of our benches, from our benches, rightly pointed out, well, there's actually been quite a lot of prosecutions and arrests already and convictions. How many more were you proposing? No real answer. The answer is that the actually opposite is it's just a soundbite. It's a soundbite. It's nothing else, it's just a soundbite. It's like the claim that all we need to do is walk in the door and we'll get a great deal out of France. Well, good luck with that. No, from my own dealings with authorities on the continent, it's not just a case of walking in the door, making a demand, and then suddenly you'll get absolutely everything that you want. So, as was touched on earlier, these may be very elegant, these may be very well worded, but ultimately, at the end of the day, they are nothing but wrecking amendments. And what they are intending to do is obfuscate the process, bung it up, delay it, and reopen routes to challenge which the bill is specifically looking to shut down, from transferring people to a perfectly safe country that is an expert in resettlement, that works with other groups on resettlement, and is perfectly able to work with the United Kingdom, and Parliament is perfectly able to take the view, and right to take the view, that we can say it is safe to do so.
Patrick Grady. Speaker, we've all heard the admonitions to speak to the amendments, but I think it is worth reflecting on the absence of any amendments in lieu on the motions paper. During the earlier stages, there were star chambers, and there were 5 families, and there were propositions to strengthen the bill, and all kinds of dark mutterings about what might happen if the bill wasn't strengthened sufficiently. But the bill cleared this House without any amendment, and now consensus appears to have broken out on the Conservative backbenches that, in fact, the bill doesn't need any further changes and should remain unamended. It doesn't need strengthening after all. And perhaps that's because this is a bill that nobody really wanted, and all it's done is create problems for the government and the Prime Minister that didn't really have to exist in the first place. It creates significant new precedents, it undermines established principles and conventions, and it moves the UK away from a framework and structure of international law that has protected our freedom and human rights for nearly 80 years since the end of the Second World War. It's not really the safety of Rwanda bill, it's the safety of the Prime Minister bill. It's all been designed to try and keep certain elements of his backbenchers happy, and on that test it seems to have failed, just as it has failed in practically every other criteria that it could be assessed against. And the evidence of that is before us in the 10 amendments, Mr Deputy Speaker, that have been made on a cross-party basis by members of the House of Lords. And as we've heard in all of the opposition speeches today, many of these are completely reasonable, sensible tests and requirements, and if the government was genuinely confident about the effectiveness of its policy and the safety of Rwanda as a place for the deportation of asylum seekers, then it should be able to accept the Lord's amendments without difficulty. The amendments to Clause 1, proposed by Lord Coker and Lord Hope of Craighead, simply lay out the criteria by which Rwanda should be judged safe. And they do so on the government's own terms, based on the treaty that it has signed. And I agree with the points made by the member for Orkney and Shetland about the significance of Lord Hope adding his name to these amendments, and I declare interest in supporting them because many years ago he conferred an undergraduate degree on me when he was Chancellor of the University of Strathclyde. The amendments to Clause 4 proposed by Lord Anderson in some way get to the heart of the debate and the issues that are at stake in the bill, because the debate isn't really about whether Rwanda is safe in general terms. And as I said during second reading, I visited Rwanda as well, as a number of members who've spoken have. I visited 2018 with the Commonwealth Parliamentary Association. It's a beautiful country, it has huge potential, and the people there have had to live through incredibly difficult circumstances. And for wealthy tourists, and those who fly in and go on safari and stay in nice hotels, or indeed go on select committee or CPA visits, Rwanda is a safe and welcoming country. But citizens who speak up too loudly with questions about the regime, or who ask why international observers have been unable to report that presidential elections have been free or fair, or perhaps belong to the LGBT community, or indeed if they're Rwandan citizens who live in London under the protection of the Metropolitan Police because they're being stalked by their own country's intelligence services, they might not find Rwanda quite as safe and welcoming. So the question isn't really whether Rwanda is generally safe, which is how the FCDO official travel guidance describes the country. It'd be interesting, actually, if anyone from the FCDO will update that guidance on the basis of this bill. The issue is whether it's safe for asylum seekers, and even then not for asylum seekers generally or as some amorphous mass, but for every individual asylum seeker that might be sent there, because everybody's personal circumstances are different. Everybody's story is unique. As the refugee charity says, we're all from somewhere. So Lord's Amendment 6 recognises that and provides for consideration of and review of individual claims and cases. These are the kinds of checks and balances that ought to be expected in any kind of decision-making system, especially ones that make fundamental choices about the future lives of the individuals concerned. But the ministers don't like to individualise this. They have lost sight, or perhaps they never really cared, about the well-being of the human beings at the centre of this debate. Now, the minister very kindly last week accepted an invitation to visit Glasgow, something I will admit none of his predecessors have been prepared to do. And I hope when he does, he will meet with and listen to some of my constituents who are supported by the Maryhill Integration Network, Refugee, Glasgow Afghan United, and other organisations who work with refugees and asylum seekers to make them welcome in the city. He will see how people who have come here on small boats, or on the backs of lorries, or through other irregular means, have not done so for purely economic reasons. They have come fleeing war, climate change, persecution, and many other situations barely imaginable to those of us who live in relative comfort and, indeed, safety here in Scotland and in the UK. And now all they want to do is to be safe and to be able to contribute to their new community and society. There's nothing good about the bill. It should be scrapped in its entirety. It's unnecessary, unworkable and unloved on all sides of the Conservative Party and all sides of the House. What the Lord's amendments do is provide something in the way of mitigation, and the House should support each of them tonight. And I hope it has the chance to divide on each of them too, because the government and its backbenchers and everybody else who supports this ought to be made to work for it. Because if they think walking around these lobbies for 2 hours is tough, they should try getting on a small boat or the back of a lorry and see how they feel about that. And if the government uses its majority to send these amendments back, then the Lords ought to think carefully about how some of their own amendments in lieu might achieve similar aims to what they're proposing, and not simply cave in at the end of the first round of what we call ping-pong. Because this bill was not in the government's manifesto, it wasn't even in the King's speech, so there's no convention or principle or anything else stopping the Lords from continuing to assist on versions of its amendments. Those of us on the SNP benches are not supporters of an unelected second chamber, but if those on the government and indeed more pertinently on the official opposition's benches do think that an unelected House of Lords is a good idea, do think that it has a role to play in the UK Constitution, then they ought not to be prepared to see the Lords simply cave in on this kind of legislation. They ought to be ensuring that their colleagues in the House of Lords continue to hold the government to account in the way that people on those benches think the UK Constitution ought to work. But in reality, Mr Deputy Speaker, what's happening is all of this is just getting us further and further away from the SNP's vision of an independent Scotland with an open and welcoming asylum and immigration system. And the more that the government and indeed the official opposition continue to push that divergence, the closer that independent Scotland will come.
Thank you very much. I intend to call the Minister to wind up no later than 10 to 8. I am expecting a minimum of 10 votes. It will be 10 votes at starting at 8 o'clock or before 8 o'clock. Those who participated in the debate should make their way to the chamber now. Mr. Shannon, we're not putting the clock on you, but if you could resume your seat at 10 to 8. Jim Shannon.
Mr. Speaker, thank you very much for that. It's a real pleasure to speak in this debate. I want to thank the honourable and right honourable members for their comments, and there's no doubt a contentious issue which we all have opinions on, but regardless of this, ensuring safety for all is everyone's main priority. My friend and colleague, the right honourable member for East Antrim, set our position out as a Democratic Unionist Party. I have 3 points I want to make in about approximately 5 minutes, and the first one is in Amendment 10. It's to do with the Afghan, those who helped us in Afghanistan. 2 years ago, 2022 February, I met an Afghan national who served alongside one of my constituents in a role, army role. I don't go into any more detail on that, Mr. Deputy Speaker, other than to say that man and his 4 children are under threat in Pakistan. I've done everything within my powers as an MP, along with other MPs, to try and get him home. We've got him a house. We've got him a job. I think they'll remember the basis. That's all we get him a place. Well, we've got him a place. We've got him a house in Newton Ards. We've got him a job in a company in Newton Ards. We'll get his children integrated into the schools, because we've done that already with the Syrian refugees, and we took them in, and they're there, and they're established, and they don't want to leave. So that's my first question to the Minister, to ensure that we can have that. And secondly, just refer back to the intervention earlier on about the Northern Ireland Court ruling. And there has been a legal decision taken in Belfast. The Minister very clearly in the intervention came back to say that that's going to be challenged. Well, Minister, I wish you well in that challenge, and I hope that challenge can be overcome against the legal opinion in Belfast Court. If it is, then we in Northern Ireland will be every bit as part as the rest of the United Kingdom. But if not, then we're very clearly different. So the Minister hopefully can go back. And the third point I want to make is in relation to, I said earlier on, I'm the chair of the APPG for freedom of religious belief, because it's a very, very important issue for me in this House, and a very, very important issue for many other MPs in this House of Commons and some of those in the House of Lords. There were 174 members, MPs and peers in the 2 houses. Gives an idea of the indication of the importance that issue has. So whenever I demand and hope that ensuring that religion is respected is so important to myself and others. Clause 2 of the bill, I'm going to speak to all the amendments and clauses and hearing exactly what you've asked me to do and others to do, and perhaps it be, well, everybody's done their own way of doing it. Clause 2 of the bill would require decision makers to conclusively treat Rwanda as a safe country, and whilst that presumption has been made, Mr. Deputy Speaker, it's crucial that the same element of presumption applies to how members of certain communities will be treated once they're there. That's the real issue. We can get all the freedom of religious belief in this great United Kingdom of Great Britain and Northern Ireland, but if we haven't got it whenever they get to Afghanistan, then the whole object of the exercise has been defeated. So I do seek that assurance. Amendment 6 of the bill will further allow decision makers to determine if Rwanda can be deemed a safe country for certain individuals or groups of similar persons. I am pleased that this protection has been addressed, as it can protect those certain groups of people of a particular religion to ensure their safety. The only concern being that when there is more scope for granting injunctions, delaying removals, we could see ourselves in a similar position now in terms of delayed Home Office decisions, where we have a long list of decisions to be made which could take months upon months to conclude their determination. I'm pleased that protections are being considered for those victims of slavery or human trafficking, given that victims are brought into the UK involuntarily. Their circumstances should be assessed differently to ensure their safety, especially for under 18-year-olds who, Mr. Deputy, who perhaps don't have a parent with them, and there must be special provisions in place. Again, I asked the Minister in the very short time that he has, and I know he hasn't enough time either, but just to make sure that that issue of those who are under 18 and maybe don't have a parent, that the protection that is necessary for them to ensure that they cannot be taken advantage of would be absolutely critical. And I conclude with this comment, Mr. Deputy Speaker. It's always important to debate these issues thoroughly, and I believe they have been debated thoroughly by all sides of this chamber with slightly different opinions. But when we've got other people's lives in our hands, these issues have to be paramount. There is no doubt Mr Deputy Speaker, that we have a problem in terms of illegal migration in this country, and my honourable friend, the Right Honourable Member for East Sandham, referred to that, and you can't ignore that issue. Nobody in this chamber can ignore that issue, from whatever party they're from. But there are exceptional circumstances for some people that consideration must be given to. In addition, no matter where they're being deported to, that it is a safe place for those with specific religious beliefs, and that they are protected. If we can protect them, and we can ensure that their freedoms and human rights and religious beliefs are ensured wherever they may be, that would be a step in the right direction for me as chair of the APPG for freedom of religious belief. But more importantly, it would be a step in the right direction for those people who are making a choice to go to another country. Mr Deputy Speaker, within your time limit, thank you.
Thank you very much. Minister.
Thank you, Mr Deputy Speaker, and may I start by thanking every single honourable and right honourable member who's contributed during the course of this debate. It has been detailed, it has been thorough, it has been constructive, and I'm grateful to each and every one who's contributed. May I start in reverse order with the honourable member for Strangford, who so often left till the end. It was delightful to see him without a time limit, on the clock at least. Can I come back to the point on Amendment 10? I will come back to that at the end of my remarks. A number of honourable members have mentioned it. In terms of under 18s, directly, Article 3 of the treaty, Article 3.4 of the agreement does not cover unaccompanied children. He'll be partially reassured, I know, by that, and there are other comments that I may have time to make in terms of his previous intervention and his important comment in relation to those of religion and faith. Can I simply point him to Articles 11 and Article 16 of the Constitution of Rwanda? I know he will look at that, and I hope he will find reassurance by it. May I then turn to the penultimate speaker, to the honourable member for Glasgow North, whom I always listen to carefully. He's renewed his invitation. I accept once again, and I confirm that I look forward to my visit with him to Glasgow. Mr Deputy Speaker, going back to the beginning of the debate, perhaps one of the most instructive parts was the exchange between the Shadow Minister and my honourable friend, the member for Torbay, because there was the foreshadowing of the comment that's made time and time again by my honourable friend, the member for East Worthing and Shoreham, who is in his place, who repeatedly makes this point. It is incumbent on anyone, and my honourable friend made this point as well, it is incumbent on anyone who disagrees with it to come up with their own solution to the problem of how we should deal with people who enter the country with no legitimate, credible case for claiming asylum and being granted safe haven, but who cannot be returned to their home country. It was a point very powerfully made also by my honourable friend, the member for Torbay, and answer once again came there none. Can I turn to my right honourable and learned friend, the member for Kenilworth and Southern? And can I agree with his opening remarks and hopefully more than just the first half of his speech, but certainly the first half of his speech, because he characterised this debate and this bill and this issue incredibly well, and I encourage honourable and right honourable members to turn to it. I agree with his assessment in relation to Amendments 2 and 3, he is right, that would transfer authority onto the monitoring committee rather than onto Parliament, which is the right place for it to be. He tempts me to delve further into issues which he rightly acknowledged are not strictly part of this debate, at least not for today. But I will consider them carefully, as he knows that I will. I'm very grateful to him for his contributions. The honourable member for Glasgow Central, on the last occasion that we exchanged on this particular bill, I undermined her credentials by not disagreeing with each and every one of her submissions. Can I start to make amends today and at least pick her up on two issues? In terms of the emergency transit mechanism, it is a treaty, it is an agreement that has been signed between the African Union, the UNHCR and the government of Rwanda. It is important. It is supported and backed by the EU to the tune of 22 million, and it has been warmly welcomed by the EU ambassador with words which I don't have time to repeat now, but which I read out at the outset of the debate. In terms of her amendments, I agree with her on this, because she said these amendments are designed to undermine the purpose of the bill. She was very plain. She was very open, in stark contrast to the Labour benches opposite. My honourable friend, the member for Rother Valley, made that point very powerfully, as did my honourable friend, the member for Torbay. And the honourable member, the member for Brighton Pavilion, also confirmed these are wrecking amendments. To put a stop to this bill, support these amendments. They are wrecking amendments. My honourable member, the member for Stone, my honourable friend, friend, the member for Rother Valley, talked about the sovereignty of Parliament. My honourable friend talked about the clear and unambiguous language, and he cited the famous paragraph 144 from the Supreme Court judgment. He also cited Lord Hoffman, and I agree with him when he speaks about the strengths of our unwritten constitution. The Right Honourable Member, the Chair of the Select Committee, again, can I just gently push back? We tackled the deterrent effect, I think, powerfully by my honourable friend, the member for Rother Valley, and also by my honourable friend, the member for Gloucester at the outset. So the deterrent effect is there. The Albania has already shown that. Numbers dropped by over 90%. Can I also just gently push back with her on scrutiny and respectfully point out once again that both myself and also my honourable friend, the member for Corby, were in front of her committee within hours of being appointed, and so much did my honourable friend, the member for Corby, enjoy that experience that he was back in front of her committee again last week. And having read the transcripts of it, having seen the reports from it, it was a constructive and an instructive exchange, rightly so, between the committee and the Minister. And not least, we had the debate last week, and we have the debate again. Scrutiny, 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 something that I very much welcome, and something that I know my honourable friend, the member for Corby, welcomes, having appeared twice in quick succession. May I turn to the honourable member for Edinburgh South West, who spoke about her visit to Rwanda. And may I just gently say that I disagree with her, and I disagree fundamentally with her assessment. I suggest that the evidence needs to be looked at in the round, and in fact that it is a powerful thing that evidence has been put forward that represents probably the spectrum of views, but it needs to be looked at in the round. In relation to Rwanda, again, I disagree with her, because we on this side, in contrast to the Honourable Lady, are confident in the government of Rwanda's commitment to implement this partnership, and we are clear that Rwanda is a safe country. And there's some very instructive exchanges between my honourable friend, the member for Hartlepool, and her powerful interventions at that stage, and also with my honourable friend, the member for Sleaford and North Hykeham. Again, I'm very grateful to her and for her speech, having again just been to Rwanda and giving her powerful assessment of where we are. My right honourable friend, the member for Witham, and again, I thank her and I'm very grateful to her. May I just pick out one of her, one or two if I have time? Firstly, the monitoring committee. She is absolutely right, and not just because one member of that monitoring committee is a former Solicitor General, but it is an important institution. It's there in detail. Paragraph 101 of the policy statement sets out more detail on that. My right honourable friend is the author and architect, if you like, of this, and therefore she speaks with great authority. I'm very grateful to her for reminding the House about this. I also do have time to mention the economic partnership, something she mentioned last Thursday as well, something that we should not forget, and that was part of the second reading of this bill as well. My right honourable and learned friend, the member for Northampton North, I'm very grateful to him for his intervention. He spoke about the laws, the essence of democracy, that the law is our servant. I heard a hear, hear from another former Solicitor General at the back of the chamber at that point, and he was right so to do. As my right honourable learned friend said, this bill is the constitutionally appropriate response to the Supreme Court judgment, respectful, listening and responding to the concerns contained therein. My right honourable learned friend, the member for South Swindon, again, the monitoring committee is the one thing that I would mention to him and gently point out to him, as my right honourable friend for Witham did. That is the right check and balance that's in place, and respectfully, my right honourable friend who spoke about the amendments 2 and 3, and that this would transfer authority from Parliament to the monitoring committee, I think is the right answer. To the right honourable member for East Antrim, I only have time to repeat that the bill applies across the entirety of the United Kingdom, but I am grateful to him for his intervention. Mr Deputy Speaker, Amendment 10. The government recognises, and I repeat, the commitment and the responsibility that comes with combat veterans, whether our own or those who have showed courage by serving alongside us. We will not let them down. These amendments, Mr Deputy Speaker, either seek to undermine the primary purpose of the bill or are simply unnecessary, as they do not support the purpose of the legislation. And I beg to move the amendments in the name of the Home Secretary.
question is that this House disagrees with the Lords in their Amendment 1. As many of that opinion say aye. Aye. The contrary, no. No! Division, clear the lobbies. The question is that the House disagrees with the Lords in their Amendment 1. As many of that opinion say aye. Aye. Contrary, no. No. Tellers for the ayes, Ruth Edwards and Amanda Milling. Tellers for the noes, Tonya Antoniazzi and Colleen Fletcher. Order, order.
The ayes to the right, 328. The noes to the left, 250.
Thank you. The ayes to the right were 328. The noes to the left were 250. So the ayes have it unlocked. Under the programme order of today, I must now put the questions necessary to bring to a conclusion proceedings. Order! Proceedings on the Lord's amendments. We now come to Lord's Amendment 2. Minister to move formally.
I beg to move.
The question is that this House disagrees with the Lords in their Amendment 2. As many of that opinion say aye. Aye! Contrary, no.
No!
Division. Clear the lobby. Is that this House disagrees with the Lords in their Amendment 2. As many of that opinion say aye. Aye. Contrary, no. No. Tellers for the ayes, Ruth Edwards and Amanda Milling. Tellers for the noes, Tonya Antoniazzi and Colleen Fletcher. Order! Order!
The ayes to the right, 324. The noes to the left, 253.
The ayes to the right were 324. The noes to the left were 253. So the ayes have it. Unlock. Now come to Lord's Amendment 3. Minister to move formally.
I beg to move.
The question is that this House disagrees with the Lords in their Amendment 3. As many of that opinion say aye. Aye. Contrary, no. No! Division. Clear the lobby. Is that this House disagrees with the Lords or Amendment 3. As many of that opinion say aye. Contrary, no. No! Tellers for the ayes, Ruth Edwards and Amanda Milling. Tellers for the noes, Tonya Antoniazzi and Colleen Fletcher. Order.
The ayes to the right were 324, the noes to the left were 253.
The ayes to the right were 324. The noes to the left were 253. So the ayes have it. Unlock. Lord's Amendment 4. Minister to move formally. The question is that this House disagrees with the Lords in their Amendment 4. As many of that opinion say aye. Aye. Contrary, no. No! Division. Clear the lobbies. This House disagrees with the Lords in their Amendment 4. Many of that opinion say aye. Contrary, no. No! Tell us for the ayes, Ruth Edwards and Amanda Milling. Tell us for the noes, Tonya Antoniazzi and Colleen Fletcher. Order.
The ayes to the right, 321. The noes to the left, 252.
The ayes to the right were 321. The noes to the left, 252. So the ayes have it. Unlock. Lord's Amendment number 5, Minister to move formally. The question is that this House disagrees with the Lords in their Amendment 5. Many of that opinion say aye. Aye. Contrary, no. No. Division. Clear the lobbies. The question is that this House disagrees with the Lords in their Amendment 5. As many of that opinion say aye. Aye. Contrary, no. No. Tell us for the ayes, Ruth Edwards and Amanda Milling. Tell us for the noes, Tonya Antoniazzi and Colleen Fletcher.
The ayes to the right, 322. The noes to the left, 249.
The ayes to the right, 322. The noes to the left, 249. So the ayes have it. Unlock. Lord's Amendment number 6. Minister will move the motion to disagree formally. The question is that this House disagrees with the Lords in their Amendment number 6. As many of that opinion say aye. Aye. Contrary, no. No. Lock the doors. Order, order.
The ayes to the right, 324. The noes to the left, 251.
The ayes to the right were 324. The noes to the left, 251. So the ayes have it. Unlock. Lord's Amendment number 7. Minister to move the motion to disagree formally.
I beg to move.
The question is that this House disagrees with the Lords in their Amendment 7. As many of that opinion say aye. Aye. Contrary, no. No! Division. Clear the lobbies. Is that this House disagrees with the Lords in their Amendment 7. As many of that opinion say aye. Aye. Contrary, no. No. Tell us for the ayes, Joy Morrissey, Mark Jenkinson. Tell us for the noes, Mary Glendon, Kim Leadbeater.
The ayes to the right were 320. The noes to the left were 250.
The ayes to the right were 320. The noes to the left were 250. The ayes have it. Unlock. Order. 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 Before we proceed, I'm informed that a member swore at one of the doorkeepers this evening, who on my instructions locked the doors. If that person is identified, the consequences will be very severe. We now come to Lord's Amendment 8. Minister to move the motion to disagree formally. Order! Minister to move formally.
I beg to move.
The question is that this House disagrees with the Lords in their Amendment 8. As many of that opinion say aye. Aye! Contrary, no? No! Division. Clear the lobbies. The question is that this House disagrees with the Lords in their Amendment 8. As many of that opinion say aye. Aye. Contrary, no? No! Tell us for the ayes, Joy Morrissey and Mark Jenkinson. Tell us for the noes, Mary Glindon and Kim Leadbeater. Order, order.
The ayes to the right, 318. The noes to the left, 255.
The ayes to the right were 318. The noes to the left, 255. So the ayes have it. Unlock. Lords Amendment 9. Minister to move the motion to disagree. The question is that this House disagrees with the Lords in their Amendment 9. As many of that opinion say aye. Aye. Contrary, no. No! Division. Clear the lobbies. The question is that this House disagrees with the Lords in their Amendment 9. As many of that opinion say aye. Aye. Contrary, no. No! Tell us for the ayes, Joy Morrissey and Mark Jenkinson. Tell us for the noes, Mary Glendon and Kim Leadbeater. Order.
The ayes to the right were 320. The noes to the left were 251.
The ayes to the right were 320. The noes to the left were 251. So the ayes have it. Unlock. We now come to Lord's Amendment 10. Minister to move the motion to disagree formally.
I beg to move.
The question is that this House disagrees with the Lords in their Amendment 10. As many of that opinion say aye. Aye. Contrary, no. No. Division. Clear the lobbies. The question is that this House disagrees with the Lords in their Amendment 10. As many of that opinion say aye. Aye. Contrary, no. No. Tell us for the ayes, Joy Morrissey and Mark Jenkinson. Tell us for the noes, Mary Glindon and Kim Leadbeater. Order.
The ayes to the right, 312. The noes to the left, 255.
The ayes to the right, 312. The noes to the left, 255. So the ayes have it. Unlock. Minister to move that a committee be appointed to draw up reasons.
I beg to move that a committee be appointed to draw up reasons to be assigned to the Lords for disagreeing to their amendments. That Michael Tomlinson, Scott Mann, Kieran Mullen, Anna Firth, Stephen Kinnock, Colleen Fletcher and Alison Thulis be members of the committee. That Michael Tomlinson be the chair of the committee. That 3 be the quorum of the committee. That the committee do withdraw immediately.
The question is that a committee be appointed to draw up reasons to be assigned to the Lords for disagreeing to their amendments 1 to 10. That Michael Tomlinson, Scott Mann, Kieran Mullen, Anna Firth, Stephen Kinnock, Colleen Fletcher, Alison Thulis be members of the committee. That Michael Tomlinson be the chair of the committee. That 3 be the quorum of the committee. That the committee do withdraw immediately. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. That concludes consideration of Lord's amendments to the Safety of Rwanda Asylum and Immigration Bill. Point of order, Mr. Clive Lewis.
Mr. Speaker, I'd like to put on record, if I could, my apologies to the to members and members of staff for an earlier outburst that I had. If I could very quickly explain, I received a message which caused me some consternation and surprise, to which I made an outburst in general at no one specifically. If I could do it again, I probably would have said something like "my giddy aunt" rather than what did come out of my mouth, and for that I apologise. But just to clear the air and put on record the fact that it was directed at no one in particular. Thank you, Mr. Speaker.
I appreciate the honourable gentleman's candour in identifying himself and the fullness of the nature of his apology, which is accepted. Before I come to motions 4 to 13 on the order paper, I should draw the attention of the House to an error under item 11 in the printed version of the order paper. This has been corrected online. The version of the draft Economic Crime and the Corporate Transparency Act 2023 Consequential Supplementary and Incidental Provisions Regulations 2024, which is before us today and which was considered by the Delegated Legislation Committee, is the draft laid on the 1st of February 2024 and not the draft laid on the 10th of January 2024, which has been withdrawn and replaced. Motion number 4, local government. Minister to move.
I beg to move.
Question is as on the order paper. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. Motion number 5, education. Minister to move.
I beg to move.
Question is as on the order paper. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. Question number 6, pensions. Minister to move.
I beg to move.
Question is as on the order paper. As many of that opinion say aye. Aye. Contrary, no. Ayes have it. Question number 6? 7. Electricity. Yeah. Question number 7, electricity. Motion number 7, Minister to move.
I beg to move.
The question is as on the order paper. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. Question number 8, electricity. Minister to move.
I beg to move.
Question is as on the order paper. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. Question number 9, electricity. Minister to move.
I beg to move.
Question is as on the order paper. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. Question number 10, electricity. Minister to move.
I beg to move.
Question is as on the order paper. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. Question number 11, companies. Minister to move.
I beg to move.
Question is as on the order paper. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. Question number 12, companies. Minister to move.
I beg to move.
The question is as on the order paper. As many of that opinion say aye.
Aye.
Contrary, no. The ayes have it. Question number 13, sanctions. Minister to move.
I beg to move.
The question is as on the order paper. As many of that opinion say aye.
Aye.
Contrary, no. The ayes have it. We now come to motion number 14 relating to the Committee of Public Accounts.
I'm here.
Sir Bill Wigan.
Thank you. I beg to move.
The question is as on the order paper. As many of that opinion say aye? Aye. Contrary, no. The ayes have it. Petition. Cat Smith.
I rise to present a petition on behalf of my constituents who are shocked and upset by the scandal that is the infected blood situation. And my constituents recognise that justice delayed is justice denied, and for that reason the petitioners therefore request that the House of Commons urges the Government to implement the recommendations of the second interim report of the infected blood inquiry without delay, and the petitioners remain, etc.
Here, here, here. Here, here.
Petition recommendations of the infected blood inquiry.
I beg to move that this House do now adjourn.
The question is that this House do now adjourn. James Sunderland.
Yeah.
Mr Deputy Speaker, it's a huge privilege to lead tonight's adjournment debate on the Cadet Expansion Programme, and I'm grateful to the Minister for responding. Almost exactly 40 years ago, it was 40 years, when I was a young Army cadet in Guildford, the combined cadet force at my school deployed to Oakhampton for its Easter camp. During that week, cadets participated in a night navigation exercise across the notorious Dartmoor. Given the cold weather and awful terrain, this would have been a challenge at any time, but we had barely left Oakhampton when thick fog engulfed us, to the point when you could not even see your hand in front of your face. Sensing the danger, the three of us in my group used all of the training we'd been given to not just get off the moor, but to complete the exercise together. The young cadets alongside me were Hamish Walker and Graham Atkinson, and I will never forget the experience. Anybody who is familiar with military service will know that heightened sense of vigilance, tension and excitement when travelling cross-country at night. Totally confident in what the map and compass were telling us and meticulously counting our paces, we worked together to double-check our navigation and agree every decision we made. And this was long before sat-nav. Utterly blind due to the fog, but trusting our instincts, training and the compass needle, it was that potent combination of teamwork, resilience, informed judgment and competitive spirit that you get with military service that saw us succeed against the odds, even as 13-year-old kids. But this was typical of what cadets still do, whether abseiling down dams, building shelters, learning to ski or shoot, escaping from a capsized canoe, preparing an ambush or cooking in the field. The skills that I acquired as an Army cadet for 5 years at school and then for a further 3 years at the University Officer Training Corps were pivotal to everything that I am today. And whilst the cadet movement does not exist to recruit people for a military career, it was so formative for me that they gave me the skills to thrive at the Royal Military Academy Sandhurst, which I now represent as a local MP, and throughout a 27-year military career. And my response to almost everything that has been asked of me since leaving the cadets probably has its foundation in my time with the cadets. So it has made a huge difference to me personally. But what of the cadet forces themselves? The MOD sponsors 5 different types of cadet forces: the Sea Cadet Corps, the Volunteer Cadet Corps, the Army Cadet Force and Air Training Corps. These are single service in nature and not tied to schools. But the 5th, the Combined Cadet Force, offers more tri-service balance and is hosted within schools with adult volunteers often coming from the teaching staff. All of these units are voluntary organisations which offer challenging and enjoyable activities for young people and prepare them to play an active role in their community while developing life skills. Whilst they do model their traditions and ethos on their parent service, they are not actually part of HM forces and do not have any formal military role. The Sea Cadets consist of over 14,000 young people and 5,000 adult volunteers in 400 units across towns, cities and ports, undertaking activities such as sailing, boating and coastal navigation. The Volunteer Cadet Corps offers something very similar, but is more tightly connected to naval families and consists of around 460 cadets and 150 volunteers located in 8 naval bases across southern England and Scotland. The Army Cadet Force has over 37,000 cadets and 9,000 adult volunteers and celebrated its 150th anniversary in 2010. And the fourth of the non-school units is the Air Training Corps, which consists of over 44,000 cadets and volunteer staff in over 900 squadrons across the UK, encouraging participants to take an active interest in aviation and the Royal Air Force. Please do.
Mr Deputy Speaker, can I commend the Honourable Gentleman for Bracknell for bringing this forward? We spoke beforehand. The Schools Cadet Expansion Programme in Northern Ireland has gone from success to success with the latest school, Kilkeel High School, in the neighbouring constituency of my Strangford constituency, becoming the newest cadet force. This week, 139 pupils from schools across Northern Ireland entered the Cyber Skills Challenge Company petition this year also, which is fantastic. So does the Honourable Gentleman agree that Northern Ireland very much is setting the targets for other cadet forces across the United Kingdom to try and match up to? And does he welcome the fact that it seems now there are almost as many people from a Roman Catholic persuasion are joining the cadet forces in Northern Ireland as there are Protestants?
Can I thank the Member for his intervention? And I completely agree. I think what's happening in Northern Ireland is a complete exemplar for the Cadet movement, and the fact we've got a balance between Catholic and Protestant children in these units is quite something. It's about cohesion, it's about community, and I really commend what's happening over there. Indeed, as for the Combined Cadet Force, units exist in over 260 schools across the UK. Traditionally, they are the preserve of independent schools, with over 200 of them hosting detachments, but there are now at least 60 units in state schools too. They offer young students a broad range of exciting, adventurous and educational activities that complement the normal school curriculum during the evening, at weekends and during the holidays. Like the other cadet units, they help to develop personal responsibility, leadership, teamwork and self-discipline, and in my view, it is no coincidence that many young cadets do emerge to be highly successful in their chosen career fields. In Berkshire, I am proud that we have a strong pedigree in terms of military presence. I could again mention the Royal Military Academy at Sandhurst, Headquarters 77 Brigade at Hermitage, the Household Cavalry Regiment and 1st Battalion of the Coldstream Guards in Windsor, 7 Rifles in Reading, and so much more. But what I really want to highlight is the Royal County of Berkshire Army Cadet Force. This currently supports over 600 cadets and 120 adult volunteers in 18 detachments, many of whom I see on Remembrance Sunday and at special events alongside the Lord Lieutenant. And I want to give a big shout too for 7 Platoon in Bracknell, which does so much locally, trains and plays hard in equal measure, and which always looks so smart when I see them. Whilst we do not have a Sea Cadets unit in my constituency, Bracknell is also home to 2211 Squadron of the Air Training Corps. Having met several of the cadets recently, it never ceases to amaze me just how much is on offer. It is possible for cadets to go flying and to set themselves up to gain pilot licences. So, to anybody watching this from Bracknell Forest, please do consider joining the Army Cadet Force or the Air Training Corps locally. It is a real opportunity. As for the CCF, the Combined Cadet Force, there are 2 detachments located in my constituency. Wellington College has an established military presence and a proud history of service. Whilst I have not yet been invited to visit, I know by reputation that it is a good one. And at Brackenhouse School in Bracknell, I've watched with wonder how this fledgling detachment has evolved under the superb leadership and vision of Second Lieutenant Berry and Second Lieutenant Gildersleeve. Getting it off the ground with virtually nothing is quite an achievement, and it serves as an exemplar for the Cadet Expansion Programme, with over 100 of its pupils in Bracknell now being given the opportunity to wear uniform, train with the British Army, conduct eventual training and learn life skills that they may not otherwise have. I cannot commend Brackenhouse School enough for everything it's doing. I'm looking forward to the annual inspection later this year. So what of the Cadet Expansion Programme itself? Well, this was first launched on Armed Forces Day in June 2012 by Prime Minister David Cameron, with the aim to deliver 100 new cadet units in English state-funded schools by September 2015. This target was reached 6 months early in March 2015, and following the achievement, the government committed an extra £50 million from LIBOR fines to further increase the number of cadet units in schools across the UK, bringing the total number to 500 by 2020. Phase 3 is now underway, and the Minister is sure to provide a progress report later. The Cadet Expansion Programme is part of the government's aim of promoting military ethos in schools. This is to instil values in young people that will help them to get the most out of their lives, contribute to their communities, and foster those essential qualities of resilience, independence and teamwork that will assist their chosen career paths. Mirroring what has already been achieved in the private sector, state schools that have set up cadet units are offering significant benefits for their young people, their own schools and the local community. Head teachers report that they have seen significant improvement in attendance and behaviour, attainment, commitment, self-confidence and discipline, and that relationships between staff and students have improved. The sense of pride that some students feel is also palpable. And given that this government is a champion of aspiration, opportunity and enterprise, I want to see the programme develop further and faster so that all pupils, irrespective of their background, can have better access to these superb opportunities. Before I close, I just want to highlight a number of areas where I feel that we can do better. First and foremost, it would be massively positive for all of our adult volunteers to be given a financial incentive for their time. Not only would this be recruitment and retention positive, it would send a clear signal that the MOD is taking the broader benefits more seriously. Our volunteers are the lifeblood of the cadet movement, and it would be remiss of me not to formally thank and pay tribute to the huge contribution that is being made by everyone who runs our detachments. We should also invest more in our cadet infrastructure by repairing some of our older halls, building new ones, and providing better training facilities such as ranges and accommodation. It goes without saying that higher operating costs should be mitigated too, that more transport should be made available, that more opportunities are provided to train alongside our regular forces, and that better adventure training and more updated equipment can be delivered. Whilst it is a considerable outlay for the MOD to provide uniforms, weapons and other personal kit, it should be possible for serviceable ex-military equipment that would otherwise be disposed of to be provided to cadet units. And closer tie-ups with regular and reserve units through the affiliation process should help to ensure that greater localised support is available for those detachments that do need it. Lastly, as someone who got so much out of the Combined Cadet Force and Officer Training Corps, I was always hugely privileged to visit and to inspect local cadet units in Berkshire, Surrey and Hampshire, particularly when serving as a commanding officer in Aldershot and at Sandhurst. Our cadets are our future. Whether they choose to join HM forces or not, their service in uniform will leave a lasting legacy throughout their lifetime, and their personal skills will be called upon, as they have for me. I also wish to thank the many organisations who continue to enable the cadet movement, not least our single service branches, such as the Cadets branch at Headquarters Regional Command in Aldershot, which forms part of Home Command, the National Cadet Training Centre at Frimley Green, which does so much to train our adult volunteers, and our Reserve Forces and Cadet Associations, or RFCAs, which support our cadet forces so well behind the scenes. Indeed, I'm now wearing the distinctive tie of the South East RFCA, which I've worked alongside for many years. Please do keep up the great work. I will conclude, if I may, by paying tribute to the other youth movements across the UK, which do so much to promote the essential values that we have commended this evening. These are far too numerous to list, and I hope that can be forgiven. But we also have the Police Cadets, St John Ambulance Cadets, the Scout and Guide Movement, Venture Scouts, Youth Sports Clubs, Young Crusader, religious groups, breakfast and after-school clubs, environmental networks, online networks, voluntary organisations, and at least 8,000 more established groups that can easily be found with a quick search online. Mr. Speaker, I'm often told by parents and teachers in my constituency that there is nothing for young people to do locally, that the government is not doing enough, that this is a key reason for antisocial behaviour, and that many are bored. My answer is usually the same. Really? But whilst there is always more that we can and must do locally and nationally, we should also be proud of what we have, not least within our cadet forces. Extending these opportunities more broadly across our society is a complete no-brainer for so many reasons, and I do hope that the Minister will not disappoint us. Thank you.
Armed Forces Minister, Dr. Andrew Mears.
Well, thank you, Mr. Deputy Speaker, and what pleasure it is to be able to respond to my honourable and gallant friend's important contribution this evening. I hope we're going to be able to reflect on what is a huge success in our country this evening. It's a wonderful thing for our communities to have cadets. I've seen them in my own constituency, and they are an important part of the local fabric, supporting occasions from Remembrance Sunday to Armed Forces Day and beyond. And we're very lucky to have them indeed, and particularly in opening my remarks, I'd like to pay tribute to the volunteers who make it possible. So many of our institutions, I'm afraid, have suffered as a result of the pandemic, and it's been extremely difficult for them to get going again. And yet they seem to have bounced back. They seem to be flourishing. And the reason for that is there are people who are prepared to give up their own time and shoulder a fair amount of inconvenience in order to serve their communities in this way, and we all owe them a great deal. The benefits of our cadet programmes to young people and society as a whole, I think, are well known and well rehearsed. And I agree wholeheartedly that the MOD-sponsored cadet forces provide brilliant opportunities for our young people. They have also been catalogued by academics from the University of Northampton, to whom I'm grateful for their rigorous appraisal, which gives sort of scientific objectivity to what I think we all understand instinctively to be the case, and that is to say that cadets are a force for good. Participation in cadets has been shown to build character, self-discipline, self-reliance. It improves teamworking, problem-solving, leadership and social skills. And it provides a boost for physical and mental health. Benefits that I am sure my honourable friend will know from his time as a cadet, which he described so well. I have to say my time wasn't quite as happy as his. I remember joining the Air Cadets briefly. I was told I was going to fly aircraft. After about 2 months, it dawned on me that wasn't going to happen. And it was going to be marching up and down for as long as I could put up with it, which wasn't very long. So I have to say I parted company from cadets much sooner than my honourable friend did, but there it is. I'm sure it benefited me at some level. Now, head teachers of schools that have established cadet units report that their cadets have improved attendance and academic attainment, as well as behaviour and self-confidence. And some head teachers are using cadets as a central part of their strategy to reduce exclusions. Cadet programmes are also a gateway to new skills, new qualifications and even employment. It is also a valuable opportunity to make young people aware of the further opportunities available in defence and defence-related industries, although, to be clear, as my honourable friend certainly was, cadet forces are not meant to be recruiting tools, but as our military footprint shrinks as it has done, cadets have assumed an even more important role in at least giving some sort of presence in many communities where otherwise there would be none. Cadets benefit the whole of society by building links between different communities, boosting social mobility and strengthening young people's resilience to becoming involved in antisocial behaviour, criminality and even extremism. In short, joining cadets is a springboard to success. It is also a powerful engine of social mobility and levelling up. The Cadet Expansion Programme is a joint Ministry of Defence and Department for Education initiative to expand cadet participation in schools. It has been a fantastic success since it was launched by the then Prime Minister 12 years ago. By March 2015, ahead of schedule, the government reached its target of establishing 100 new combined cadet force units in state secondary schools in England. Then in November 2019, again ahead of schedule, we reached our further target of establishing 500 new cadet units across the United Kingdom. Funded with 50 million from LIBOR fines, it benefits many schools in less affluent areas. To provide renewed impetus to the programme, the government had also by this time outlined a further aspiration to increase the number of cadets in school units to 60,000 by April 2024. But cadet units require a significant amount of personal commitment from school leaders and volunteers, and in spite of successes, around 50 of the units established since 2012 have failed, often as a result of changes to a school's leadership or priorities. Now that's a pity, but it in no way detracts from the leadership and drive of senior leadership teams that have advanced the cadet programme, to whom I pay tribute. And as we approach April 2024, although cadet numbers in schools have increased 15% since April 2020 to more than 54,000, COVID has had an impact here, as in so much of our national life. It is clear that we will not reach our 60,000 aspiration in the challenging timeframe we had set. And it is not only the direct impact of the pandemic that has slowed progress. In addition to cadet activities being halted or limited by COVID restrictions, participation has also been affected by the resulting change in school priorities, with many reorienting away from extracurricular activities to prioritising catching up on lost learning, which is perfectly to be understood. Given this context, the fact that we have already achieved 90% of our ambition to have 60,000 cadets in schools is a great credit to every individual and school involved in our cadet expansion programme. We have also made progress on a number of other fronts to provide the greatest level of support to school cadet units that we can. In the last year, we have developed a combined cadet force engagement and communication framework. We have worked with the single service cadet forces to improve the delivery model, and we have extended funding for regional schools cadet expansion officers. A report by academics at the University of Northampton has found that more than 91% of head teachers surveyed considered their cadet units to be a good investment for their school, and a whopping 98.9% of head teachers reported an improvement in the resilience of participants. With most recent estimates calculating the cost of participation at £836 per cadet, I call that a fantastic value for money investment in their future, in our future, and for the future of the country. But you don't have to take my word for it. The academics who conducted the study concluded that school-based cadet units are delivering excellent value for money, as well they should, since the IPPR estimates that the cost of just one school exclusion is £392,000. I will.
Minister, one of the things that certainly impresses me amongst the cadet force in my constituency, whether it be the Army, the Sea Cadets or the Air Force Cadets, is the number of young girls equal the number of young boys in the cadets. I think it's really encouraging to see that. I know it's something that the Minister, yourself Minister, would like to see as well. Is that something that Government and yourself as a Minister is trying to promote?
Well, I absolutely do, and as the proud owner of 5 daughters, each one of which were involved at some level in cadets, I can certainly endorse the Honourable Gentleman's remarks, and I'm impressed all the time by the number of young women who are engaged and looking to the future as defence, though this is of course not a recruiting exercise, is increasingly female in its composition. That has to be a positive thing. Now, I remain absolutely determined, Mr Deputy Speaker, to do all I can to ensure we continue to grow the number of cadets in our schools. And as we recover from the pandemic, we must meet our 60,000 aspiration as soon as possible, so that schools such as Brakenhale School in my honourable friend's constituency can continue to flourish. The schools programme is, of course, complementary to the very successful community cadet forces, which my honourable friend has referred to. I pay tribute to the very active units in my own constituency and to the volunteers who sustain them. These community cadet forces are as popular as ever with our young people, and in terms of numbers have mirrored the growth of our school programme. Most recent figures show that we have more than 83,000 community cadets, which represents a 14% increase on the previous year. Of course, none of this can happen without the selfless and invaluable contribution adult volunteers make. The good news is that adult volunteers can indeed receive some remuneration for their efforts, depending on the activities they are engaged in. Historically, cadet units have had to put up with some fairly basic accommodation, and my honourable friend touched upon some of that. However, we continue to make considerable efforts in improving facilities for cadets, not least through the ongoing Reserve Estates Optimisation Programme. Mr Deputy Speaker, school cadet units have been transforming the lives of our young people for more than 160 years. Once the preserve of independent schools, 65% are now in the state sector, a reversal of the previous situation where 75% of cadet units were in independent schools. Like the rest of our modern cadet forces, they embody the ethos of the armed forces, and they are laser focused on helping young people develop and reach their full potential in whatever walk of life they choose. And whilst COVID has slowed our ambitions somewhat, thanks to our Cadet Force 2030 strategy, the government has plans in place as well as the commitment to deliver their continued growth, ensuring our cadet units in schools and communities will continue to transform the lives of more and more of our young people for many years to come.
The question is that this House to stand adjourned. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. Order, order.